reply to the averments in paragraph 3 of the writ petition, deponent emphatically submits that same are not correct, rather destroyed. In this regard, it is humbly submitted that there was no advertisement for the recruitment of class 4 employees in the Justice of Kandhamar Goud, Fulwani, in the month of December 2001. No application was received from the eligible candidates, nor any examination or test was conducted. My humble submission itself continue reading. The petitioner has not filed any copy of the advertisement, copy of the call letter with his petition. The other district judge, Sri M.C. Rai, has made some illegal appointment in class 4 post without conducting an interview and without observing the provisions made in Rule 71 of GR and CO Criminal Volume 1. So the appointment of petition dated 17/1/2002 is illegal. My appointments, my lord. Just read on, sir, because this is also important, because you keep saying that you have produced all the certificates. Just see this. It is true that the petitioner was directed to produce educational certificate, etc. Write this office letter so and so, Annex 3 of the writ petition. But the petitioner did not file those certificates in spite of the fact that he received the notice on 18/4/2003. The Honorable Portfolio Judge of the Justice, Sri S. Naidu, made a surprise visit and observed that the petitioner has submitted a certificate indicating that he has passed class 8 in Sanskrit, but he has no knowledge in Sanskrit. The Honorable Justice Naidu has observed that the veracity and genuineness of the educational certificate was not inquired into by the then district judge. Accordingly, the Honorable High Court have directed the opposite party number 1 in the letter number dated 3/8/2004 to initiate necessary proceedings against the person illegally appointed. Thereafter, the opposite party number 1 has issued so cause notice to the petitioner who has submitted his so cause, and after due inquiry, opposite party number 1 was satisfied that his appointment was illegal, so his services were terminated. No inquiry was held. No, but the certificate itself is suspicious. All these appointments were made without advertisement, sir, and this is not the only appointment. This MC Rai seems to make several such illegal appointments. And my lord, what I humbly say, my appointment was challenged by Premananda Mahapatra, my lord. This annual court held that my appointment is valid. Let's see that. The lordship kindly see paragraph 4, page 6 to the writ petition. No, but the reply to that is in the next paragraph of the counter. What is your name? The petitioner's name? Hemant Kaur. Hemant Kumar. Hemant Kaur. So where is that order? Which annexure is the order? Order under challenge, madam. No. You said it is challenged in the High Court and upheld. I mentioned the writ petition, madam. Page 6, para 4 of the writ. No. Were you a party there? Yes, madam. I have opposite party. No, but you have not enclosed that order at all. I have quoted the entire order set, madam. No, but the names of the petitioners are not indicated in this, sir, in the order. Well, in the written notes I am filing, I indicated the names of the petitioner in the set case. But no notice went to the High Court. What merit this honorable court rejected dismissal and upheld my appointment, my lord. On the very ground, my lord, that my appointment was in violation of rules. No, but the para 6 is very important. Para 6 of the counter. No, that order, sir. But we make it clear that henceforth, and when appointments are made to such post, the district judge Fulbani and registered civil court. No, Justice Naidu, I think, visited the district after this. After this. But before that, before the Honorable Justice Papan also visited and inquiry report submitted, my lord. That's all right. All right. And Honorable Justice Papan and the then portfolio judge held that interview was held and my appointment was legal. There is no advertisement, sir. There is absolutely no advertisement. Where is your advertisement? You have given so many. No, I have not given. But about that, show us the advertisement. Where is the GRCO followed? GRCO Rule 71. No. Where is it followed? The my lord. Lordship, can you see the inquiry report submitted by the portfolio judge Honorable Justice Papana, paragraph 4, my lord. Paragraph 4. Yes. At page, my lord. 7, my lord. Two written notes. May I read, my lord?
Yes, yes.
My inquiry reveals that the district judge Sri Rai has appointed one Prasanna Kumar Mallik and another Sri Hemant Kaur, present person, as peons. But the allegation that Hemant Kaur is an illiterate is not true. He has passed class 8, 7th, which is a minimum qualification for appointment as peon. So far as Prasanna Kumar Mallik is concerned, he is a
There's no advertisement.
I have also
Clearly, the appointment is not through an advertisement. Nice. Take it up at 10:30 actually. Sorry? Oh. why his services should not be terminated, since his appointment is illegal. Full stop. The petitioner submitted a reply to the show cause notice on 30th August 2004, stating that after coming to know of the vacancies in class 4 post, he had submitted an application, and after due selection, he was appointed. Paragraph. Thereafter, the interim order was passed terminating the petitioner's services. Paragraph. Pursuant to the notice issued in the present petition, you say the present petition was filed inter alia pointing out that the appointment of the petitioner as well as one Prashant Kumar Malik had been challenged by some candidate peons in OJC number 1468 of 2002, and this court, by an order dated 2nd May 2002, dismissed the said petition. To stop. It is submitted that with the dismissal of the above petition, there could not have been any further reopening of the question of the validity of the petitioner's appointment. Stop. Mr. Dr. J.K. Lanka, learned counsel, the petitioner submits that the interim order is violative of the principles of natural justice. Stop. It is a one-line order, not indicating the reasons for the conclusion that the petitioner's appointment was illegal. Stop. Dr. Lanka also referred to an inquiry report submitted by Justice M. Papana on the allegations leveled against the district judge regarding illegal appointments made of persons in class 4 posts. And how the said report concluded that the appointment of the petitioner could not be said to be illegal. Full stop. Reliance is also placed on the decisions in Makhan Singh versus Narayanpura Cooperative Agricultural Service Society Limited, AIR 1987 SC 1892. PK Yadav versus GMA Industries Limited, 1993 3 SEC 259. In support of the submission that the interim order is unsustainable in law and requires to be set aside. Paragraph. Mr. P. K. Mudali, learned additional government advocate appearing for the opposite parties, drew attention to the counter affidavit filed for the present petition by the District and Session Judge Kandamal Bhawan of Kulbani, where inter alia and para 5 it is pointed out that the appointments of not only the petitioner but certain other persons in class 4 posts was done by the then district judge illegally, without conducting any interview and without observing the provisions of Rule 71 of the GRNCO bracket criminal bracket volume 1. Stop. No advertisement was issued, no applications were received from eligible candidates, nor any examination or test conducted. Stop. It is pointed out that the petitioner is unable to file the copy of the advertisement, copy the call letter, etc. of this petition. Stop. The counter affidavit also mentions how the portfolio judge at the relevant time, Justice A.S. Naidu of this court, made a surprise visit to the district and noticed that the petitioner had submitted a certificate indicating that he had passed class 8 in Sanskrit, but in fact had no knowledge of Sanskrit. Full stop. Justice Naidu observed that the veracity and genuineness of the educational certificate was not inquired into at the time of appointment of the petitioner. Full stop. As a result of the above visit of Justice Naidu to the district, the High Court on 3rd May 2004 directed the District and Sessions Judge, he said DNSJ, to initiate necessary proceedings against the persons illegally appointed. So thereafter, the show cause notice was issued to the petitioner. Full stop. In reply thereto, the petitioner claimed ignorance about the selection procedure and contended that he was not responsible for the illegality committed by the then DNSJ in appointing him. Full stop. Even with this reply to the SCN, who could not produce the advertisement, the call letter, the copy of the merit list, etc. Full stop. Accordingly, the opposite parties concluded that the petitioner's appointment is illegal. Stop. Accordingly, the termination order was issued. Paragraph. Dr. Linka insisted that since this court on the judicial side had by its order dated 3rd May 2002 in OJC number 1468 of 2002 upheld the appointment of the petitioner, that question could not have been reopened by the opposite parties. Stop. Having perused the paragraph, having perused the order dated 2nd May 2002 of this court in OJC 1468 of 2002, it is seen that while it is true that the court declined to interfere with the appointment of the petitioner at that stage, it was not after issuing notice to the opposite parties in that petition. So the dismissal was in limine, probably the very first hearing of the petition. So there is no occasion for this court to examine in some depth whether the procedure outlined in the GRCO criminal for making such appointments was in fact followed. Consequently, the order dated 2nd May 2002 cannot be said to put a stamp of approval on the legality of the petitioner's appointment. Paragraph. Moreover, the visit undertaken by Justice Naidu to the district was subsequent to the above order of the court on the judicial side. Stop. That visit revealed that the certificate produced by the petitioner to say that he had passed class 8 in Sanskrit appeared to be of doubtful veracity, particularly since the petitioner was not able to speak Sanskrit. Paragraph. The plea that the imperial order is in violation of the principles of natural justice also does not appear to be correct. So, stop. A show cause notice was indeed issued to the petitioner prior to his services being terminated. So, stop. His reply to the said SCN was not found to be satisfactory. So, stop. Interestingly, the petitioner did not dispute that his appointment was without any advertisement or selection process. Full stop. He only laid the blame for the illegality in the process on the doorstep of the DNSJ. Paragraph. Consequently, the court is not satisfied that any grounds have been made out for interference with the impugned order terminating the petitioner's services. The petition is accordingly dismissed. No order is to cause.
Equal list item number 5.
This slightly covered.
Yes.
Order. I think against the SSK and in favor of the department. I'm asking of that. Council remember that groundwater protection, I purchased the groundwater.
Correct.
And they lost it. And coincidentally, the two orders. The two orders are passed by the father of Justice Thomas. And he was at that time the accounts member.
Okay.
And I had the occasion to appear many times before.
I see.
And this is golden opportunity to work with the lordship. Because the lordship have got profound knowledge.
No, it's all right.
All branches.
Okay.
And since he has long way to go.
No, it's nice that he's sitting today here with me.
Beg your pardon?
It is nice that he's sitting here with me today. So,
Yes.
I think this matter is covered by another judgment that Mr. Kaura was arguing
Yes.
for the department.
Right.
In 2008, 25 VST it is reported. Ramlal oil mill.
Ramla Royal, that says.
So this is also the same.
It is the same associate, that Ramlal oil industry.
Yes, that is reported.
Yes.
25 VST.
all right. The question that arises for consideration in the present revision petition, which arises from an order dated 5th January 1995 of the Orissa Sales Tax Tribunal in essay number 2912 of 91-92 is similar to the question that has been framed and answered by this court in its order dated 28th March 2022 in STREV 159 of 2007 bracket Messrs. KR Oil Industries of Dhanamandal was the state of Orissa. Paragraph. In fact, the said order also was the said revision STREV 159 of 2007 also arose from a similar order dated 5th January 1995 of the Orissa Sales Tax Tribunal. The question, namely, whether the tribunal is justified in holding that section 5 bracket 3 of the CST Act was not attracted, was answered in favor of the SSC and against the department. So the question is answered likewise.
In favor of the revenue. In favor of the revenue.
Was answered in favor of the department and against the revenue. SSC, sorry, SSC. The question is answered likewise in the present petition as well. The revision is disposed of. Disposed. Correct. Disposed of.
Yes, I've got substantial relief in the price.
I see.
Only this part.
Correct.
Right. Also,
List item number 6. May I please, Your Lordship? The facts of the case is that I have manufacturing of country liquor.
Yes.
For manufacturing of country liquor, I purchased rectified spirit. What has happened, Your Honor, in course of regular assessment, my purchase of raw material under Form 34
All
declaration.
quality amount, Your Lordship, 60,000, 5,000, 50,000, all these are.
As for batch,
Quality
it will for 4 years it will come for around 2 lakhs. Just I will take 1 minute. The whole issues has been cropped up for non-incorporation of rectified spirit in my RC matters. Subsequently, by virtue of judgment passed by this honorable court in 112 STC, the rectified spirit has been incorporated in the RC from the date of application. Therefore, the whole basis of this assessment goes thereafter. But the demand remains. Therefore,
If it is with retrospective effect from the date of registration itself, this adding an entry, rectified spirit has been added now to the RC. So the demand should go.
And your lordship, tribunal order is something else. Tribunal order says that in actual fact, no such manufacturing processing resulting in any end product is produced by the respondent.
Now the certificate itself has got the entry, there's no need for him to do anything more.
Your lordship, let it go to the.
While admitting this revision petition.
You have purchased it
My
for
lords.
manufacture.
Yes, my lords. I manufacture, my lords. In course of regular assessment, it was not disputed. In course of reopening also, the assessing officer as well as the first tribunal authority has held that I am manufacturing. But however, in the ex parte order passed by the tribunal and a tribunal, it has been held that the course, the activity doesn't amount to manufacture. My lords, my humble submission, it is a new fact has been recorded by the tribunal in absence of the part.
All right. While admitting this revision petition by the order dated 19th February 1999, the following questions were framed by this court for consideration. We reproduced two questions from that order. Paragraph. The facts in brief are that the petitioner carries on business in manufacturing and selling country liquor within the jurisdiction of the sales tax officer (STO), Cuttack 1 East Circle, Cuttack. So the petitioner is a registered dealer under the Orissa Sales Tax Act 1947, OST Act, and holds the registration certificate. Paragraph. For the year 1980-81, the STO reopened the assessment under section 12(8) of the OST Act. Stop. Pursuant to the notice issued to it, the petitioner appeared, produced the books of account. Stop. By the assessment order dated 30th June 1983, the STO raised an extra demand of tax of rupees 42,689 and imposed a penalty of rupees 20,000 on the ground that the petitioner was not entitled to purchase single quotes rectified spirit unquote by furnishing declaration in form 4. Stop. Tax was calculated at 7% on the rectified spirit, and after crediting the tax paid at the time of purchase of the rectified spirit, the balance tax and penalty was demanded. Paragraph. The petition then went in appeal before the Assistant Commissioner of Sales Tax (ACST) Cuttack 1 range. Full stop. By the order dated 11th February 1988, the appeal is allowed by the ACST and the demand was annulled.
Dear Lordship, beg your pardon, ACST has allowed the appeal by observing that the payment against Form 4 is to be paid by the seller,
Right.
not by the purchaser.
All right. The ground on which the appeal is allowed was that the payment against Form 4 had to be made by the seller and not the purchaser. Paragraph. The state then went in second appeal before the tribunal. Stop. By an order dated 30 June 1994, the tribunal allowed SA number 1120 of 1988-89 thereby restoring the assessment order. Full stop. The advocate for the dealer was unable to appear on account of illness and the order was passed ex parte. Full stop. Paragraph. Aggrieved by the above order, the petitioner filed a reference application to section 24(1) of the OST Act on 17 November 1994 and raised the questions that have been framed by this court by the above order, seeking reference of those questions to this court together with the statement of facts. Paragraph. By the order dated 28 September 1995, in reference application number 133 of 1994-95, the tribunal framed two questions of law as above, and observed that the selling dealer who sells goods at concessional rates of tax on obtaining a declaration in the prescribed form for the purchasing dealer must satisfy himself that the goods sold to the purchasing dealer are mentioned in the certificate of registration of the purchasing dealer for such purpose. Paragraph. Actually, in the present case, the registration certificate of the present petitioner has been rectified, has been amended to incorporate rectified spirit, right?
Yes, ma'am.
And this has been with effect from the initial date of registration itself. So, that being the position, the question of any extra demand being raised on the petitioner would not arise. Full stop. In other words, the conditionality pointed out by the tribunal for availing the concessional rate of duty, rate of tax, in fact stands fulfilled in the present case. Paragraph. Consequently, the question framed by this court by the order dated 19 February 1999 is answered in favor of the SSC and against the department by holding that the petitioner is not liable for paying any extra tax, and further that the levy of penalty was also not justified. Stop. The revision petitions disposed of the above terms. The other matters you say in view of the order passed today in STREV 161/2007, these petitions are also disposed of by answering the questions that arise in favor of the SSC and against the department.
12-13.
Item number 12 and 13 also relates to different years, same issue.
Correct. 12 and 13, you say again in view of the order passed today in 161/2007. These revision petitions are also disposed of in the same terms by answering the questions that arise in favor of the SSC and against the department.
Obliged.
We will list item number 7.
Your Lordship, item number 7, it is a state revision, Your Lordship. Your Lordship, the sole issue in this case is that the sale of timber through auction to the outside purchaser, whether it can be interstate sale or interstate sale, Your Lordship. The question of law at page 4 of the revision petition, Your Lordship, whether on the facts and in the circumstances of the case, the finding of the law and tribunal in holding that the transaction of auction sale effected by the SSC is without link between sale and movement of goods is correct. Now, Your Lordship, may kindly turn to the tribunal order, page 13, annexure 3, and the operative portion is at page 14, paragraph 3.1.
This is Orissa Forest Corporation holding a auction sale
Your Lordship,
to outside purchaser.
Your Lordship.
So the movement of goods will go out, the goods will move out only.
No, Your Lordship. It is, Your Lordship, it is covered by this honorable court's order.
What?
As well as by honorable Supreme Court, the larger bench, the honorable five judge bench has decided the issue. Because the fall of Haman.
So we'll answer the question in your favor then in terms of this judgment, but no demand will be raised. There's no need to raise now after 15 years to chase him and correct from Orissa Forest Development Corporation.
Orissa Forest Development Corporation is a dealer, your lordship.
Yes, yes. After how many years are you going to recover? This is 2007, we are in 2022.
Your lordship, but the finding.
Your only concern in these things is that it should not be precedent. That you have enough judgments of this court, of the Supreme Court, answering it in your favor.
I think 2019, the same forest corporation case has been disposed of.
That case already Honorable Supreme Court has stayed those matters. All those matters, your lordship, recently, this Honorable Court in 2019, that BD, that Kendu Leaf's case.
No. In 2019, this forest corporation case. I think
That has been also stayed by Honorable Supreme Court.
other assessment here.
That judgment has been stayed by Honorable Supreme Court.
Then how can it be stayed? If it has been decided in favor of the department, how will it be stayed? Stayed at the instance of the SSC.
No, in favor of the SSC. In some cases, in that BD cases, Kendu Leaf's cases, this Honorable Court has passed the order by cognizing the judgment of this Honorable Court in Ashok BD and KB Shah judgment of Honorable Supreme
So,
Court.
sale of BDs in auction will be an interstate sale. That's what this court has held.
This court has held by cognizing the judgment of Ashok BD.
No, as far as this timber sale,
Malam,
by auction, you are saying it is covered by this Simlipa.
civil part. And also your lordship.
What is the tax effect here, sir?
Tax effect, your lordship, more, there is 11 lakhs. 11 lakhs 20,000, your lordship. Your lordship, also the Honorable 5-judge bench, so far as the.
But no notice has gone even, sir, in this. You want us to issue notice now in 2007? It's so unfair, sir.
Your lordship.
So the statement of the case is not yet received, sir. Why should we entertain all this, sir? First of all, statement, we have to call for the statement, they have to make the statement. This is all sales. But everything is auction sale and to outside purchases. The sale is complete at the point of auction. Yeah, so it all of those it's intra. Right. No, but here we'll have to now for the first time issue notice in 2007. Counsel for the petition department, which is the petitioner before the court, refers to the judgment in Simlipa Forest Development Corporation Limited, the state of Orissa, 1995, 96 STC, 627, as well as A.V. Thomas and Company Limited, this is Deputy Commissioner of Agriculture Income Tax and Sales Tax, Trivandrum, AIR 1964 SC 569, to urge that auction sale of timber by the SSC OFDC would amount to an intrastate sale and not an interstate sale, even if it is made to outside purchasers from outside Orissa. Paragraph. Accordingly, the following questions are framed for consideration. Where are the questions set out? Oh, the question has already been framed. Oh, this court has on 3rd May 2008 already framed the question for consideration. Stop. this, when you frame the question, no notice goes to the other side.
Your Lordship, only the record LCR has been called for, might be called for, but no notice. is
No, but
required.
what happens when does the other side come to know that you have, this petition has been admitted? On admission, it has to go, no? Where's
Have you
that?
filed affidavits? That time. Check up.
Then he has appeared. Your Lordship, the advocate for the opposite party has appeared.
Process we filed, notice issued to opposite party for appearing show cause. Oh, they've entered appearance. All right.
Entered appeared.
Ah. Aha. He says no instruction. At present, there are no instructions. Don't we simply allow? They're not appearing because it's already been served. The sole opposite party OFDC has already been served. In fact, at one stage, Mrs. B. Panda had filed the appearance. So today, however, Mr. Panda states that he has no instructions.
However, we are not disengaged by the corporation. They have some new panel of advocates.
So, okay, states he has no instructions and perhaps a new panel of lawyers. However, today none is appearing on behalf of the OFTC. Paragraph with the position in law being clear by virtue of the aforementioned two decisions. The question is answered in favor of the department and against the SSC by holding that the tribunal erred in treating the auction sale effected by the SSC as an interstate sale, when in fact it was an intrastate sale. The revision petition is disposed of accordingly. Right.
Weekly list item number 8.
Item number 8, it is paltry amount, Your Lordship.
All right. The amount being insignificant, the question of law is
8,000.
left open for decision in some other appropriate case. The revision petition is disposed of.
Weekly list item number 9.
Item number 9, Your Lordship.
I am
I'm unfortunate to argue this case. Your Lordship may kindly turn to the tribunal's order, the finding of the tribunal. The law in tribunal,
You mean the reference order, reference rejection order?
your Lordship, the full bench order, Your Lordship, at page 20. Paragraph 4. In this connection, it is pertinent. Meanwhile, the appeal filed by the dealer had already been disposed of by the full bench in their second appeal. Number so and so, the full bench of the tribunal has allowed the appeal of the dealer in full.
And that has not been challenged.
That is not challenged, and that is not with me, Your Lordship. So without praising that judgment of honorable full bench, Lord full bench, so how can I argue, Your Lordship?
All right. The impute order of the tribunal.
And also the demand is 1,23,000.
All right. You say after the tribunal by an order dated 18/10/1995 declined to refer the questions as urged by the department for consideration of this court under section 24(1) of the Orissa Sales Tax Act 1947, for the year 1984-85. The present petition was filed by the state, by the department. Full stop. On 29 June 1999, the court framed the following questions for consideration. Paragraph. As rightly pointed out by Mr. Sunil Mishra, learned AGA appearing for the department, the order dated 3rd October 1994 of the tribunal notes in para 4 is under. Reproduce para 4, page 20. Mr. Mishra very frankly states that he does not have a copy of the aforementioned order dated 16/10/1992 and is also unable to state whether the said order has been challenged. To stop. In the absence of any challenge to the above order, no fault can be found with the tribunal in its order dated 3rd October 1994 declining to answer the questions in favor of the department. Paragraph. Accordingly, the questions framed at this court by the order dated 29 June 1999 are answered in the affirmative, that is in favor of the SSC and against the department. Revision is disposed of.
Oblations.
List item number 10.
My lords, my appearance may be noted. I'm appearing for the opposition.
10 is already covered by that other one.
My lords, in item number 9, I am submitting my appearance may be noted.
9 his appearance.
Obligation.
Item number 10 itself paltry amount for the opposite party.
10 is a paltry amount.
Your Lordship, in the assessment, this, the demand is 1,37,000.
No, anyone, is anyone appearing in 10? None appears, dismissal, non-prosecution.
List item 11.
On behalf of Mr. Lal, your lordship, no instructions.
No instructions disposed of.
List item number 14.
Does he want to pursue the matter any longer?
Counsel petitioner does not wish to pursue the matter any longer. Disposed of.
List item number 15.
Yesterday, some matters were that the impugned order has not been filed. Certified copy of the impugned order.
The defect pointed out by the registry has not been cured for over 10 years now. The petition is accordingly dismissed for non-prosecution.
16 is delay of 684 days.
Further, there is next one, 16.
Yes.
The delays of 600 days and the explanation offered is totally unsatisfactory. Accordingly, MC number 306 of 2011 is dismissed. Consequently, the appeal is dismissed.
List item 17.
Sorry, maybe you're here. What happens? The present petitioner was not noticed or opportunity of hearing was not given while disposing of a proceeding under section 25 of the OHRE Act, that is Orissa Hindu Religious Endowment Act 1951. That was a proceeding for recovery of possession from the petitioner and from opposite party number 3 and 4, pro forma opposite parties. That was a proceeding initiated by opposite.
You are the purchaser.
What
Who are you? You are the purchaser.
tenant under
Tenant.
under the DT. That remains outside the vesting. That cannot be vested.
No, you did not receive any notice or you were heard?
Not noticed. Not noticed. Subsequent to the order of this honorable court in the earlier writ application, I was not noticed. Previously, originally I was noticed. We have filed our joint objection to the in the proceeding, but subsequent to the writ application disposal of the writ.
What is the impugned order, sir? Where is the impugned order?
Impugned order is at annexure 6.
This is without notice to you.
Yes, and state petition was also heard behind my back. There is a petition because suit was
This
pending.
type of cases, your lordship is allowing the petitioners to go for a civil suit under section 25 sub plus 3. Because they have every right, because he is a tenant. The order was passed against the DT and he is in possession of he is an unauthorized possession. It is the DT's property. If he has got any civil right, he can exhaust his remedy under this code of civil procedure.
Whether I am an unauthorized occupant or not, that has to be decided in the 25 proceeding itself.
No, that has to be decided in the civil proceeding because
Because under section 73.
only endowment authority is to see that land is recorded in the name of the DT and somebody is in possession, DT is not in possession.
Your
Then in
Lordship may
case-
kindly have a glance to section 73 of the act. That will clarify the whole position, entire positions.
25(3).
73 million. The jurisdiction is barred, civil court jurisdiction is barred. If a person is in occupation in contravention of the act, that has to be decided by the authority, not by the civil court. Civil court will not decide whether I am an unauthorized occupant or not.
Religious endowments.
That is within the jurisdiction of the competent authority. That is section 73, your lordship may see. Your honor may see section 73 of the act. That makes the position clear. Civil court jurisdiction is barred. Has your lordship got it? That is section 73, bar of suits in respect of administration of religious institution. No suit or other legal proceeding in respect of the administration of a religious institution or in respect of any other matter or dispute for determining or deciding which provision is made in this act shall be instituted in any court of law except under and in conformity with the provisions of this act. Here, section 25 clearly provides that if I am an unauthorized occupant, then I am to be evicted. That question cannot be decided by the civil code. Am I clear to your honor? Section 25 will also may see at the same time.
I will draw your
What does
lordship's
it
kind
do?
attention
What
to
does it
section
do?
25 surplus 3. Any person aggrieved by the action of the collector may institute a suit in the civil court to establish his right. So what my learned.
That is subsequent to the order passed by the
Yes,
competent authority.
subsequent to the
Here,
25 order. Now you are
Order
challenging
is
the
a violation
25.
of principle of natural justice because I have not been heard. I have not been given an opportunity to adduce evidence whether I am an unauthorized occupant or not.
No,
I'm
but
the tenant.
that you can raise in the suit, sir.
That can be decided by the competent authority. They have not given me an opportunity. They have
But
decided.
that you can challenge. That's why it says any person aggrieved with the action.
Agree by the
That-
order. By the order. Now, Annexure 6.
That
Then
order is
establish civil
impugned.
code.
That order is impugned in
Establish
this case.
right
You are
to
aggrieved by
establish
that
law.
order.
No. That order which you aggrieved by
Yes.
can be challenged in a suit. That's what 25(3) says.
But order is bad. Here, order is bad. Order is
Sir, because the order is bad, you will challenge it in a suit, sir. Just read 25(3).
Section 73, which my learned senior is showing, that is relating to administration of the DT.
Correct.
Endowment, endowed property.
Not
This
removal
is unauthorized occupation
Correct.
of DT's property. That is either by the endowment commissioner or civil suit.
No,
And section 69 subclause 2 of OHRE Act provides that civil suit can be filed provided a previous notice like section 80 notice your lordship knows. Section 69 subclause 2 notice is to be given to the endowment commissioner prior notice before filing of the suit. That has to be complied. But so far as suit is concerned, section 25(3) is clear.
Yes.
The order which is impugned in this honorable court in this writ petition can be challenged in the civil. Alternative remedy is available, so writ petition is not maintainable.
Kindly, I will invite your honor's attention to annexure 3, the previous order of this honorable court. Your honor may see that is paragraph. Both the provisions have been discussed, section 25 and 73. At page 21, your lordship may see. At page 21, paragraph 5. This court had law and counsel for the parties at length and perused the relevant documents annexed to the pleading. Section 25 of the OHRE Act deals with recovery of immovable trust property unlawfully alienated. The said section stipulates that in case of any alienation of any property belonging to or endowed for the purpose of any religious institution in contravention of section 19 of the Act, the commissioner, after summary inquiry, as may be prescribed, and on being satisfied that any such property has been so alienated, may send requisition to the collector of the district to deliver possession of the same to the trustee of the institution or the person.
That is the enforcement. That is the enforcement section.
The said section further stipulates that any person aggrieved by the order of the collector may institute a suit in civil court to establish his right. Thus, the commissioner is vested with the jurisdiction to recover illegally alienated trust property in a summary procedure. The order of recovery can't be made only after the commissioner arrives at a finding that the property belongs to or given or endowed for the purpose of any religious institution. And the said property has been alienated in contravention of the provisions of the OHRE Act. Section 73 of the OHRE Act creates an embargo
To harmonize
Again.
both the sections. See, you cannot ignore 25(3). So if to harmonize 25(3) with 73. 73 is in a different domain altogether.
Yes, my lord. That is in different domain. That is relating to some other aspect of
that is
the.
collector's action.
No. That is.
Collector's action, you can challenge in a suit. 73 relates to administration of the deity's properties, institution, the institution of the deity.
And also section 25 procedure.
Whether it's being done for the purposes for which it was established, all that. Those questions are different questions, sir.
I don't think.
But how he is
And
prejudiced?
no provision can be treated redundant.
But I don't think how he is prejudiced by that. The civil suit is a very wide remedy available to them.
Much better remedy.
They are much better remedy the legislature have provided.
Correct.
So why?
You see, the challenge in the present petition is to an order dated
Your Lordship,
16th April 2010, passed by the Commissioner of Endowments, Orissa Bhubaneswar, in OA number 90 of 1993, which has been passed under section 25 of the Orissa Hindu Religious Endowments Act 1951 bracket OHRE Act. The further prayer is challenging the further order dated 13th May 2010, passed by the COE in OA number 90 of 1990, again under section 25 of the OHRE Act. Paragraph. A preliminary issue has been raised by Mr. D.K. Monti, learned additional government advocate, bracket AGA, appearing for the opposite parties, regarding maintainability of the present petition. Stop. He refers to section 25 bracket 3 of the OHRE Act, which states that any person aggrieved by an order made therein by the collector, it says, is the collector same as commissioner?
collector, that is their meaning.
Collector will enforce that order. The eviction order will be passed by the commissioner and that will be enforced before the collector. So the section 25 order itself is amenable to a civil court.
No,
But in this case, has the collector passed a consequential order?
No, I think.
collector has passed the requisition.
No, it's only the collector's order, sir, which can be.
Yes, that is what I am submitting.
Only the collector's order has to be
Yes.
challenged in civil suit.
Yes, not the endowment commissioner's order.
But collector is to act upon the endowment
No, no.
commissioner's order.
We are
Yes,
not at that
I
stage.
understand. your
We are not at
lordship.
that stage,
I
sir.
understand. I understand your lordship.
And 73 is clear, my lord, or in respect of any other matter in this court for determining or deciding which provision is made under this act. So section 25 is relevant, is covered under 73, which I can agitate before the civil court. That is section 73, I am reading.
Then your lordship, if
See, he'll send a requisition to the collector to deliver possession.
yes, my lord. Collector is to enforce the order.
So collector under 25N will be guided, and the collector passes an order that can be challenged as civil
Yes,
suit.
that finding that I am an unauthorized
So
occupant.
we are not at that stage yet.
The finding that I am an unauthorized occupant cannot be challenged.
Anyway, we'll deal with
That
that
is binding. Finding is binding without hearing me.
paragraph.
That should be
Section 25
offset.
reads as under, reproduce the whole of section 25. It is seen that under section 25 bracket 3, a person aggrieved with the action of the collector can institute a suit in the civil court, establish his rights. Stop. That order passed by the collector would be under section 25 bracket 1 of the OHRE Act, which will be consequential upon a requisition being sent to the collector by the commissioner. Of endowments, bracket COE. So in the present case, it has been sent, sir. Come to page 28.
28 of the brief.
Issue requisition to the collector.
To deliver possession.
Requisition has.
But that consequential order has not been passed by the collector, sir.
No.
In the present case, although by the order dated 13th May 2010, the COE directed issuing a requisition to the collector to deliver possession of the case land. There was no consequential order passed by the collector. Stop. Meanwhile, the petitioner moved this court and a status quo order was passed and a stay order was passed on 12th January 2011. As a result, the collector was not in a position to pass any order under section 25 bracket 1 of the OHRE Act. Stop. The result of the above discussion is that the occasion for the petitioner to invoke section 25(3) of the Ocheri Act to question the order of the collector has not arisen in the present case. So the preliminary objection is accordingly negative. Paragraph on merits, counsel for the petitioner points out that the petitioner is a tenant in the suit land, but the impugned orders of the COE have been passed without notice to him.
My lord, he was noticed, he appeared through his Ashok Kumar Satpathy. Kindly
No.
see annexure.
No, no,
page-
originally he was
No,
noticed.
Just a minute, just a minute, please allow me, please.
Allow.
Kindly see page 27.
Yes, 26 he is there, very much there.
27,
Ashok
and the Ashok Kumar Satpathy is the opposite party.
Correct.
He entered appearance through Sri Arun
Even
Mahanti
page
advocates.
22, even page 22. No steps into it.
22. Yes, that was earlier remanded by the
Yes.
honorable court.
After
And
remand, I have
after
no notice.
remand, he entered
I have
appearance.
no notice. After remand, I have no notice. That is what I am submitting.
No, no, but at that stage of 13th May order, notice did go to you, sir, or it did not? Because advocate for opposite parties, it says, page 26.
Pardon me, no?
Page 26, the
26,
Advocate for the opposite parties, it says.
26.
Page 26, sir. Order dated 13th May 2010 of the Commissioner of Endowments.
26.
The second impugned order.
and page 28 also, the OP is contended in the objection that their mother
Very
got
much
the
there, your lawyers are there.
No, no.
lawyers are there, they have filed
No, no.
objections.
No, no.
Come to page 26, sir.
26 of the brief.
Yes, sir. Court of Commissioner of Endowments.
Yes,
Annexure 6.
yes.
Just look at the cost title. It is your name, correct?
27. that-
Ashok Kumar Satpathy.
That
Yes.
is you.
And
That was annexure 5, the requisition.
no.
Requisition was issued.
Just show him the paper book.
I received the copy of the.
Kindly see the paper book. This is your paper book, sir.
And the next page is the OP,
Yes,
paragraph
because
2.
I was appearing earlier, my advocate's name appeared.
No.
No, yes, that is.
No, judgment, in the judgment also it is referred.
Para 2, just again show para 2.
Yes.
I think,
para 2
I don't know how your paper book, these documents are not there. You are giving a paper book to us without keeping all these documents with yourself.
Para 2 of the judgment.
The OP is contented.
The OP is contended in the objection that their mother got the case land from the case DT through its executive
No,
officer.
no, that was the joint objection I had filed earlier.
Uh-huh.
Sir, this is not earlier, sir. This is 2010. This is what you are challenging in this petition.
Prior to remand, my lord. Prior to remand, we had filed joint objection to the petition. We had appeared through lawyers.
So this is the last order passed. This is challenged before us. We have to deal with the challenge to this order.
No, my lord.
This is 13th May 2010.
If my honor friend shows that there was notice after remand, then I have no case, my lord. Let order should be called now.
No, why should we call? This order says that your contentions are valid.
This is a mistake, my lord. This is a mistake. Because I was earlier appearing through lawyers, panel of lawyers' name appears in the judgment, on the face of the judgment. And joint objection was earlier filed.
Once an order
I-
records
before remand.
contentions. No, petitioner. No.
That name appears because I was earlier appearing. After remand, there was no notice. After remand, there was no notice to me.
We don't know that, sir. It's only your say so.
And I have stated on affidavit your lordship has said in the writ application itself, I have no notice. There is no counter to this.
Accordingly, the case is prayed to be dismissed. The impugned order reveals that there was a clear objection from their side and the court has.
No, objection was there.
Court has
Objection was there
considered.
earlier. Before remand, there was objection. from
And
our side.
another point I would like to submit before, once the Honorable High Court, you prefer the writ petition, the Honorable High Court remanded the matter. Is it not your duty to pursue the matter before the Endowment Commissioner? You will remain silent and awaiting that notice will come to you. At your instance, this remand order was
That
passed.
was not our remand application, writ application. Writ application was filed by the Endowment Commissioner.
I am very sorry.
But
You
you
are a
appeared
party.
in that,
You are a
sir.
party to that case. I am very sorry.
I appeared before the, before, I inquired before the Endowment Commissioner. Endowment Commissioner office told that you will be noticed.
Where is that written?
there is no
Have you
notice.
pleaded in this writ petition?
Yes, I have pleaded, I have
Where?
pleaded. I have pleaded, I have pleaded into the application. There is assertion, clear assertion. And just say, listen. Yes, para 7 year occupancy at page 7 of my brief application, that after disposal of the aforesaid brief application, whenever the petitioner went to the office of the opposite party number 1 to inquire about the posting of the case, he was told that the date would be communicated to him as and when the matter is fixed.
There's no reply filed. That's the whole problem, Mr. Monte.
Taken upon a
Yes,
particular-
No reply filed.
No
about
reply.
the-
No reply to this.
All right, you see, as far as the merits is concerned, although the order dated 13 May 2010, passed with the COE, records the appearance of counsel for the present petitioner, that is Ashok Kumar Satpathy, and states in para 2 that open quotation, the OPs contended with the objections that ... unquote. Counsel for the petitioner asserts that no notice was in fact issued to the present petitioner by the COE
After the remand order.
after the remand by this court of the proceedings to the COE. Paragraph. In para 7 of the writ petition, it has been averred as under. There has been no reply filed to the present petition to contradict the above averment. So this is despite the fact that notice was issued way back on 12th January 2011. Paragraph. Therefore, the court proceeds on the basis that the above averment is correct. Paragraph. In that view of the matter, the impugned order dated 13th May 2010 is hereby set aside, and the matter, namely OA number 90 of 1993, is remanded to the file of the COE Bhubaneswar to be proceeded with in accordance with law.
And a time bound may be fixed.
Yes. Considering that this case is nearly 30 years old, the COE is requested to dispose it off within a period of 4 months from today, that is in any event not later than.
After giving notice, your lordship.
No, again.
So now I'm going to ask you to appear on that day, no more notices, on 16th August,
Then
not
what
later than
happens
16th August
here?
2022. The matter will now be listed before the COE on 9th May 2022, on which date the petitioner will appear along with the downloaded copy of this order. No further notice is required to be issued to the petitioner for this purpose.
My lord, what I beg to submit, Lord Lingaraj is the requisitionist. He is, perhaps the Lord is not appearing through any advocate. So they have to pursue the case before the commissioner. So the Lordship may direct that notice will be issued to the.
Yeah, the copy of this order also be sent to the opposite party to enable them, opposite party number 3,
Lord Lingaraj Mahaprabhu.
yeah, to enable them to make necessary arrangements to appear before the COE on that date. The status quo order passed by this court, the stay order passed by this court on 12th January 2011 will continue. No, there's no need for that. It's been set aside. All right. The petition is disposed of in the above terms.
Weekly list item number 18.
Wait, please, Your Lordship. Your Lordship, this is a matter where on the charter of demands placed by the opposite part number 3 union, a reference has been made. With reference is that Your Lordship may kindly see, is that annexer 9, page 92. Page 92, that is whether the existing wage structure of piece-rated contract workmen working under different contractors as per annexer 3 of JK Paper Mills, which includes basic wages, DA, VDA, annual increment allowances such as night shift allowances, education allowances, attendance allowance, HRA, etc., needs any upward revision. If so, what should be the details? Your Lordship, thereafter, this principal employer, the petitioner is the principal employer, Your Lordship, under whom the different contractors are there, and they have engaged the piece-rated workers who are sought to be represented by the opposite part number 3 union. Your Lordship, in the Form D issued initial to the reference, Your Lordship finds at page 12. Your Lordship may come to page 12, Your Lordship. This is the Form D. In the Form D, Your Lordship, JK Pepper Mills, Your Lordship finds memo number 990, that page 12, Your Lordship.
Yes.
They copy to the Chief Executive Works, JK Pepper Mills, JK Pur, for information and necessary action. Because it was not a party at the relevant time, Your Lordship, before the conciliation. And in the parties were the two memos before that, Your Lordship. All the contractors who are there, the names are there, they have been issued, Your Lordship. And the conciliation also ended in failure. The next page, the failure report was there. And upon that, this reference has been made. And in this reference, Your Lordship, I had filed a petition for deleting the name or expunging the name of the principal employer because they were sought to be arrayed as an opposite party employer, Your Lordship. This application, my application has been rejected, Your Lordship. That is why I am before Your Lordship. And
Where is the order rejecting your application?
My Lord's order is at page 28, Your Lordship. Page 28. Page 28, Your Lordship.
Yes.
The case record is posted to today for orders on the matter of release of the management of JK Paper Mills. Heard the petition of the management, so and so, and objection thereto. The peruse the written submission by the parties on perusal of the reference sent by the government of Orissa. It is clearly mentioned therein that chief executive is one of the party in the present proceedings as mentioned in the reference. In this
contract labor, in the contract labor situation, are you not the principal employer?
I am the principal employer under the Contract Labor Regulation Abolition Act, Your Lordship. But in a reference, the employer is always the contractors, Your Lordship. And vis-a-vis the contract labor and the union, contract labor, the disputes arise and the settlements also have reached, Your Lordship. And in this particular case, there have been 3 settlements already in 2008, 2014, and 2017.
No, but in a contract labor matter, isn't the principal employer also a necessary party?
My Lord's, principal employer becomes a necessary party where it becomes to a prohibition of contract labor, and the prohibition is not attached and acted upon by the parties, and in an industrial dispute raised by the contract labor for regularization, then becomes the principal employer a necessary party, Your Lordship.
Okay. Yes. Not in this kind of
not in these types of cases, Your Lordship. And this matter, there are 3 settlements, and on the first settlement, that is 5/10/2008, which was also challenged by the OP number 3 union before this honorable court. They have already withdrawn that and they have accepted that settlement. There is WPC number 18852 of 2008 that has been disposed of on 13/7/2017, Your Lordship. 17.
Where is that order?
My Lord's, order, Your Lordship, because this is subsequent to this filing of the writ petition. I have not been able to do it, Your Lordship. But 13/7/2017 is the order, Your Lordship. OP number 3 had filed. They have withdrawn that, Your Lordship.
My Lord, may I pray before Lordship from BC, my Lord? I am for the OP number 3.
Yes.
Samit Sangha CI2, my Lord.
Yes.
Letter of demand was submitted on 24/1/2006, which we have annexed under annexure A3 to our counter. My Lord, conciliation was initiated and failure report submitted. The principal employer was a party to that, and the reference order was issued, and they are also the principal.
No, it's not a party, sir. It's only being sent to them for information.
My Lord, no. They were a party in the failure. Your Lordship may see the failure report, annexure 3.
Yes.
Annexure 3, running page to the writ petition, page number 13.
Yes.
That is the chief executive JK Paper Mill.
No, that has been sent to them for information.
Yes.
No, my Lord. They are in the reference order.
At this stage, sir, at that stage is a question of party, no, not a party. That's not a adjudication as such. It's a conciliation proceeding.
In the reference order, they are also a party.
So being a party is neither here nor there, sir. For the purposes of
our annexure, my Lord, D/3 running page to 33 of our counter. Your Lordship may see, they are the party to the reference order, my Lord.
That's why they're here, sir. They're questioning that very, making them a party is why they're questioning.
My lord,
That's why they have filed this petition.
My pardon, my lord, they have not challenged the reference order. They have
No, no.
challenged the order of the.
No, they don't have to. When a reference order comes, they go to the labor courts and delete us as a party. And then they've come here, sir.
My lord, may
The nature of the dispute is such that they are not a necessary party to the nature of that dispute.
No,
Just read the reference, then you can make your submission. Read the reference.
my lord, I have read, my lord, already this honorable court has decided in WPC number 8569 of 2006, order passed on, my lord, 20th January, 20th April 2011 by a division bench Honorable Chief Justice V. Gopal Gowda and B. N. Mahapatra, while the reference order was challenged by the Indian Oil Corporation, they dismissed the writ petition and also imposed 5,000 cost, my lord. My lord, the reference, the party in the, let them tell in the labor court what they want to say.
No. What will they say about this basic existing wage structure of piece-rated contract workers?
My lord, there are several 23.
This is following the agreements entered into with the contractors.
They have entered agreement with other pocket unions.
No. Is there any agreement entered into with the principal employer? That's the question.
My lord, they may have attended agreement, but with the pocket unions, not with this union, my lord. This union mainly exposing the cause of huge 100 of contractor workers, my lord. 500 to 600 contractor workers are suffering for last 10 years. They have stayed the proceeding, my lord.
Sir, if you had agreed that they are not a necessary party, why not the proceeding would have been over?
My lord, they have not challenged the reference order. Already their name has been included in the reference order.
That is why they are here, sir.
Pardon, my lord?
They are before this court only because of that.
They have not here also in the prayer, they have not challenged the reference order, my lord.
Sir, if they challenge the order of the labor court, which declines to exclude them from the reference, it amounts to challenging that, sir. Anyway, there's no point. It's all right. It's all right. Anything else? Anything else?
69 of 2006 order, your lordship.
My your lordship may kindly also see their petition. They have filed another petition at page 30, your lordship, 30.
Yes.
Where they have sought to include so many persons, that is contractors as parties. And your lordship may come to the next page, point number 32, serial number 32. They want to add me as a party to the reference.
And this chapter of demand was consolidated upon where the principal employer was a variable party and the reference order was issued where the principal employer is the party and they are in the labor court stalling the proceeding, my lord, with various pleas and they have taken help of this article 226 and exploiting the workers.
All right.
And this 8569 of 2000 Indian Oil Corporation versus Union of India, your lordship may peruse, where this honorable court, they have challenged the reference order, they rejected the writ petition and imposed 5,000 cost, my lord.
All right.
Even bunch of this, my lord, V. Gopal Gowda, Honorable Chief Justice, and B. N. Mahapatra.
All right. JK Paper Mills Limited has filed this petition, questioning an order dated 29 December 2010, passed by the Labour Court, Jaipur, Koraput, in ID case number 2 of 2009, rejecting the prayer of the petitioner for deletion of its name as a party to the aforementioned case. That is ID case number 2 of 2009. Paragraph. The background facts are that, no, it must be mentioned at the outset that by an order dated 24 January 2011, directing notice to issue to the opposite parties. That is the government of Orissa, bracket opposite party number 1, the contractors, bracket opposite party number 2, the contract Shramik Sangha, bracket opposite party number 3. This court states the operation of the impugned order. Paragraph. The background facts are that the petitioner has a plant and factory at JK Pur and is engaged in the manufacturing production of different kinds of paper. Full stop. Contract laborers are employed in different areas of the plant and factory. Admittedly, the petitioner is the principal employer in terms of the contract labor bracket regulation abolition bracket Act 1970 bracket CLRA Act bracket. Paragraph. Concerned about the non-revision of wages, allowances, and other benefits, the opposite party number 3 union raised a dispute for which conciliation proceedings were held between the workmen and the contractors.
23 point charter of demand submitted 24/1/2006.
Full stop. The conciliation proceedings began with notice being issued on 22nd March 2007 by the district labor officer conciliation officer to 31 contractors of the petitioner, as well as the workmen represented by the opposite party number 3 union. A copy of the said notice was marked to the present petitioner. To stop, the conciliation proceedings ended in a failure. On 17 March 2009, the government of Orissa referred the following dispute between the contractors and the union to the Labour Court Jaipur for adjudication. Take from para 8, page 5 of the writ petition. Paragraph. When the workman filed a statement of claim in the Labour Court pursuant to the above reference, a copy thereof was served on the petitioner. Thereafter, notice was issued by the Labour Court to the petitioner asking it to file its written statement. Paragraph. Asking that its name be deleted from the aforementioned ID case number 2 of 2009. The petitioner filed an application before the Labour Court on 20th November 2010. On 29/12/2010, the said petition was rejected by the Labour Court on the ground that as principal employer, the petitioner's name was reflected in the schedule of reference and its name could not be deleted as it is a necessary party in the proceedings. Paragraph. It is this order that has been challenged the present writ petition and has been stayed with this court while directing notice to issue. Paragraph. This court has heard the submissions of Mr. Narendra Kishore Mishra, learned senior counsel appearing for the petitioner, and Mr. Pradeep Kumar Das, learned counsel appearing for the union. Paragraph. Mr. Das repeatedly urged that the petitioner was both a necessary and proper party to the proceedings, since it was the principal employer and the workmen were governed by the CLRA Act. Full stop. However, as pointed out by Mr. Mishra, the dispute referred for adjudication to the Labour Court is not about regularization of the contract laborers, but about the wages to be paid to them. Including DA, VDA, annual increment, allowances, and so on. This is a matter exclusively within the domain of the agreements arrived at between the contractors on the one hand and the laborers on the other. Full stop. The petitioner certainly is not a party to those settlements. Paragraph. Given the nature of the dispute referred for adjudication by the Labour Court, the court is inclined to agree with Mr. Mishra that although the petitioner is the principal employer vis-a-vis the workmen, given the nature of the dispute, it is not a necessary party to the ID case number 2 of 2009.
And my lord, the charter of demand submitted, the number one demand is the regularization of contractor workers.
So that has not been referred to the Labour Court, sir. The court notes that the issue of regularization of the workmen is not before the Labour Court.
Yes, my lord.
Consequently, the court sets aside the impugned order dated 29/12/2010 of the Labour Court and directs that the petitioner is not a party, will not be a party to ID case number 2 of 2009. The petition is disposed of in the above terms.
Weekly list item 19.
I know the.
Who's in 19, sir?
My lord.
Weekly 19.
My lord.
None appears to the petitioner. Dismissal, not prosecution.
I am for the opposite party, Your Lordship.
All right.
Weekly list item number 20.
May please, Your Lordship. The other day, my lord has passed the similar order, wherein enhancing the 25,000 to 50,000.
How many such matters are there, sir?
Total 5 matters. This is the last matter. 4 matters has been duly disposed of by this one.
All right. Same order.
Weekly list item 21.
None appears. Dismissal, not prosecution. Memo is taken on record. No instructions. Dismissal, not prosecution.
Weekly list item 22.
To may please, Your Lordship. Here, my lord, the noting is the opposite party workman has not appeared and the notice has not been made sufficient or it has been returned.
You say till date for more than 10 years, that is after the filing of the petition. Notice is yet to be served on the opposite party number 2 workman. The court does not propose to grant any further indulgence for this purpose. The petition is accordingly disposed of.
Weekly list item 23.
Challenging the award.
How do you decide it, sir, without notice to the workman?
Earlier occasion notice was issued, neither
AD from opposite party number 2 not received.
not received.
All right.
And here reinstatement or in lieu of 50,000.
Hardly anything, sir. Anyway, he may not even go for enforcement. Yes.
Item 23.
23, no instructions.
No instruction. Disposed of.
Item number 24.
In 24, what has happened, we joined as on daily wage basis as peon in the year 1983, and thereafter subsequently posts were 24 posts of peon were created, after which we moved this state administrative tribunal, and the tribunal at page 23 directed that we should be regularized. Page 23, your lordship may kindly have a look for a moment. I'll just read that page 23. And work charged employees should be absorbed in government service in a phased manner as and when vacancies arise by taking into consideration the seniority position. The applicants are still continuing as NR employees for the last 15 years. In view of the directions of the Apex Court and more particularly in view of the resolution of the state government in the finance department dated 15/5/1997, these applicants are entitled to be absorbed in the government service as regular class 4 employees. There is no dispute that vacancies were available from 30/12/1983. For the reasons stated above, the respondent number 3, the chief engineer, is directed to absorb the applicants as regular class 4 employees of the establishment with effect from the date on which the vacancies arose in such post by keeping in view the government resolution dated 15/5/1997. Now, after this order was passed, they were not regularized. Then finally, I filed a contempt, and you may kindly come to page 55. In the content proceedings, the concerned the chief engineer was directed to appear in person, and thereafter.
So you have to unmute.
Yes, ma'am. Sorry, my lord. And at page 59, the contempt was dropped on the ground that petitioners have been taken under the work charge establishment, and the counsel for the petitioners before the tribunal gave a concession saying that he does not want to pursue with the matter. But the fact remains, my instructions are this petitioner never gave that undertaking to the council to make a statement before the tribunal that they are agreeable with that work charge establishment post, my lord. So that is how I am before your lordship.
No, but it can't be simply like a say so, like this orally. Have you said that?
I understand, but unfortunately, again, in the writ petition, this ground also has not been taken.
Then we can't entertain it, sir. We can't entertain it.
I understand, but actually that was the latches on the part of the council before.
No, we won't go behind that, sir. The challenge in the present petition is to an order dated 2nd February 1999 of the Orissa Administrative Tribunal
in fact, they are not challenging that order also. That is.
No, in that order, we have been allowed to be regularized. Why should I challenge that order?
Oh, I see.
That 10/5/2011 order is not under challenge.
No, okay.
This annexure
the present petition is for a direction to the opposite parties to regularize the services of the petitioner in terms of a finance department resolution dated 15th May 1997 and in light of the order dated 2nd February 1999 passed by the Orissa Administrative Tribunal. Paragraph. The background facts are that the 4 petitioners at the time of filing the present petition were all peons brought over to the work charged establishment of the executive engineer, Mahanidhi Barrage Division, Gandarpur District, Cuttack. Gandarpar District, Cuttack. This is Gandarpur or Gandarpar? Gandarpur.
Gandarpur, my lord. Yes, ma'am.
The case of the petitioners is that they were appointed as peons on daily wage basis on 2nd November 1984, 1st October 1984, 1st May 1984, and 1st July 1985, respectively. So on 30th November 1983, the Irrigation Power Department of the state government is supposed to have created 24 posts of peons. To stop. It is stated that despite several representations by the petitioners for regularization of their services, for regularization bracket approval of their services, a resolution was adopted by the Finance Department on 15th May 1997 regularizing NMR of the DLR job contractors, contract workers who had been engaged prior to 12th April 1993. Paragraph. Initially, a writ petition was filed in 1991 in this court, which was then transferred to the OAT in TA 29(C) of 1993. So by order dated 2nd February 1999, by directing that you have a copy of the order dated 2nd February 99.
It's at page 22, my lord.
22.
Page 22, my lord. Annexure 3.
Giving a direction to the chief engineer to absorb the petitioners as regular class 4 employees. Open quotation with effect from the date on which the vacancies arose in such posts. Keeping in view the government resolution dated 15 May 1997. Paragraph. When the above order was not complied with,
Page 53 is the contempt order. In the first contempt order,
contempt petition was filed. Where is the order of the contempt, sir?
page 53 is the first order, Annexure 11 by B.
Page 59.
Page 59 is the final order. 53, the chief engineer was asked to appear in person, and page 59 is the final order where it was dropped.
By order dated 10th May 2011. The contempt petition was dropped after the chief engineer appeared and filed a compliance report. That compliance report is at page. Where is the compliance report, sir?
I'll just check. That I think we have not annexed, my lord. Page 50, my lord. Annexure 11 by A.
No, that's not the complaints.
No. That's only an affidavit seeking 4 months' time.
Yes, my lord. After that, I think we have not filed any other document.
In your counter, what do you say? Additional counter also you file.
Counter affidavit, paragraph 12. Sorry.
Page 56 is that office order where we have been put under the work charge, my lord. That can be treated as a compliance. Annexure 12.
An office order was issued on 4th May 2011, bringing the petitioners over to the work charge establishment in the post of attendant. Paragraph. Since this was accepted to the petitioners, the contempt petition was closed. Full stop. In the present petition, there is no averment that petitioners were misled into agreeing to treat the order dated, the above office order dated 4th May 2011, issued by the SC Drainage Circle Gandarpur, bringing the petitioners over to the work charge establishment as compliance of the directions earlier issued by the OAT. Paragraph, the challenge the present petition is to the order passed by the OAT on 10th May 2011, dropping the contempt proceedings in CP bracket C number 71 of 2000. Counsel, the learned senior counsel for the Mr. Gautam Acharya, learned senior counsel petitioner, sought to submit that the counsel who appeared for the petitioners before the OAT did not have instructions to agree to the dropping of the contempt proceedings. Stop. However, or to even accept the above office order dated 4th May 2011 as being in compliance with the directions issued by the OAT. Paragraph, the fact remains that there is no such averment anywhere in the present petition. Stop. In the absence of any such pleading, it's not possible for the court to doubt the correctness of the statements made in the order of the OAT, dropping the contempt proceedings. Paragraph. Consequently, the court is unable to find any ground to interfere with the impugned order of the OAT. The petition is accordingly dismissed.
May I just submit one more thing, my lord? Out of these 4 petitioners, 2 are still working and they have already put in more than 35 years of service. And if you lords may kindly see the order dated 9/8/2018 of this honorable court, there the state was asked to find out as to whether there are any still posts vacant where they can be regularized. Order dated 9/8/2018. If you lords may kindly observe that, if there is any post, they can be considered.
That is our stand in the counter affidavit also. To say that there was no vacancy, they could not give.
Given the stand taken in the counter affidavit, as and when vacancies arise, the cases of petitioners 2 and 4.
1 and 4, my lord.
1 and 4, who are still in service, can be considered for regularization by the opposite parties. Right.
Oh, bless me.
Weekly list item 25. Item 25.
The cell deed of 2011, it was not registered, so they perhaps in the
None appears dismissed non-prosecution.
Weekly list item number 26.
None appears dismissed non-prosecution.
Weekly list item 27.
None appears dismissed non-prosecution.
Weekly list item number 28.
Wait, please, your lordships. Your lordships, in this item numbers 28 to 35, these are 8 matters, one bunch, your lordship, but by different employees, your lordship. These matters are under the Minimum Wages Act. If your lordship may kindly have a look at section 20 of the Minimum Wages Act, that is regarding to how the claims are to be processed by the authorities under the Minimum Wages Act. Your lordship may kindly have a look, section 20, your lordship, of the claims, your lordship, MW Act. Minimum Wages Act 1948, your lordship.
I may be pardoned to appear, my lord. All these 8 cases, my lord, the order of the Minimum Wage Authority are under challenge by 3 sides, my lord. Contractor, principal employer, and workman, my lord.
I'm coming to
total 24 writ petitions, my lord. May I pray to list all together all the writs, my lord?
I'll come to that. Your lordship may kindly have a look at section 20, your lordship. Claims. The appropriate government may, by notification in the official gazette, appoint any commissioner for workmen's compensation or any officer of the central government, exercising functions as a labor commissioner for any region or any officer of the state government not below the rank of labor commissioner or any other officer with experience as a judge of a civil court or as a stipendiary magistrate to be the authority to hear and decide for any specific areas all claims arising out of payment of less than the minimum rates of wages or in respect of the payment of remuneration for days of rest of or the work done on such days under clause B or clause C of subsection 1 of section 13 or of wages at the overtime rate under section 14 to employees employed or paid in that area. You also may come to subsection 2, where an employee has any claim of the nature referred to in subsection 1, the employee himself or any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf or any inspector or any person acting with the permission of the authority appointed under subsection 1 may apply to such authority for a direction under subsection 3, provided that every such application shall be presented within 6 months from the date on which the minimum wages or other amounts become payable. Provided further that any application may be admitted after the said period of 6 months when the applicant satisfies the authority that he had sufficient cause for not making the application within such period. There will also be subsection 3. This is most important. When any application under subsection 2 is entertained by the authority, the authority shall hear the applicant and the employer or give them an opportunity of being heard, and after such further inquiry, if any, as it may consider necessary, may without prejudice to any other penalty to which the employer may be liable under this act, direct 1. In the case of a claim arising of payment of less than the minimum rates of wages, the payment to the employees of the amount by which the minimum wages payable to him exceed the amount actually paid, together with the payment of such compensation as the authority may think fit, not exceeding 10 times the amount of such excess. 2. In any other case, be the payment of the amount due to the employee together with the amount of such compensation as the authority may think fit for exceeding 10 rupees, and the authority may direct payment of such compensation in cases where the excess or the amount due is paid by the employer to the employee before the disposal of the application. Your Lordship, may now come to subsection 6, Your Lordship. Every direction of the authority under this section shall be final. And 7, every authority appointed under subsection 1 shall have all the powers of a civil court under the Code of Civil Procedure for the purpose of taking evidence and of enforcing the attendance of witnesses and compelling production of documents, and every such authority shall be deemed to be a civil court for all purposes of section 195 and chapter 35 of the CRPC, Your Lordship. My lords, what has happened in this case, this petitioner in this petition is challenging the order dated 25/8/2011 passed by the Regional Labour Commissioner Central, who is the appointed authority under the Minimum Wages Act for the area, Your Lordship. But my humble submission before Your Lordship is that the entire order is passed erroneously under section 20 within bracket 3 of the MW Act, which I just read out, Your Lordship. This BITM, that is opposite part number 3, that has engaged the petitioner as a contractor to upkeep the internal environment of the Regional Science Center, which is situated at Bhubaneswar, Your Lordship. That is OP number 4. By providing manpower on payment of lump sum service charges, Your Lordship. That was for a particular period, Your Lordship, 2007 to 2009, Your Lordship. And they had provided 8 persons, 8 employees, casual employees for the said period, Your Lordship. They have been paid because the state government minimum wages was there, so they have been paid as per the state government minimum wages. There is no dispute over that also. And on 7/1/2010, Your Lordship, the opposite party number 2, who is the employee, he filed a claim under section 22. Your Lordship may find that is at page 21, which is quoted, Your Lordship, of the order. 21, Your Lordship, of the order, Your Lordship. Your Lordship finds the period of the claim, Your Lordship. 3/3/96, Your Lordship gets it.
Yes.
Yes, from 3/3/96, it is a tabular form has been given. From 3/3/1996, and it has continued, Your Lordship, unabated. Your Lordship comes to page 22 last, Your Lordship. 1/10/2009 is the last date.
So you say limitation.
Yes, that's number 1 limitation, Your Lordship. That's one point. Second point is that if Your Lordship, there's
no, you are appearing for the contractors, is it?
I am for the contractor, Your Lordship. I am the paymaster, Your Lordship.
Ah,
I am the paymaster, Your Lordship.
right.
And I have been paying them also the government, senior state government minimum rate of wages. There is no dispute over that also. But the whole thing is that if the land authority under the central government, he is to assess, he is to also direct what amount is payable and for which period, Your Lordship. That has not been done in the entire case, Your Lordship. No evidence is taken, only arguments have been heard, and it has been directed, Your Lordship. See, I will not take much time of yours. The direction is at page 40, Your Lordship, last page, Your Lordship. Internal page 21 of the order, Your Lordship.
So basically, they're saying the central government rates have to be paid.
Yes, they are saying central government rates are to be paid, but there also there is a catch, Your Lordship, because on 7th August 2000, there is a particular notification which came into being for the first time that is also discussed, and that is covering these particular employees, Your Lordship, because at least 6 of them, 6 of them that is covered, Your Lordship. That is for in 2008 for the first time that it came, Your Lordship. So if it has come for the 2008, then the relevant period for consideration will be 2008 to 2009. That will be my humble submission, Your Lordship.
No, but here the direction is from 2007, 1/9/2007.
That is the period for which I have.
1/9/2007 to 1/10/2009.
So it's only a matter of 1 year, sir. You said 2008, the order
No,
says
I'm not saying-
2007.
But that has to be quantified, Your Lordship. Quantification has not been done, Your Lordship. That is the important aspect of the order, Your Lordship.
Sorry?
No quantification has been done. It has been left open to the parties to deliver it. That is not the intent of the act, Your Lordship.
No, just come again. What has not been done?
Quantification, Your Lordship. What quantification? What I am to pay?
Quantification.
Quantification.
What should be quantified? Suppose they say you pay the differential. You've paid state government rates, you now pay central government rates, and pay it from 1/9/2007 onwards. So what is wrong with that?
That is exactly because the claim is different, Your Lordship. The claim has been differently placed, Your Lordship.
Meaning?
The claim, Your Lordship finds page number 21 and 22.
Yes.
The third column, Your Lordship, actual MW per day. Actual MW, Your Lordship gets it. Third
Yes.
column, Your Lordship. First
Yes.
is period of work, second is received wages per day, and third is actual MW per day, Your Lordship.
Right.
That is different, Your Lordship. From each page, that is different. And there are not so much of the notifications, Your Lordship. And the notification which came into being, Your Lordship.
No, but they're asking the operative portion
Fine.
only says that you have to pay from 2007 onwards.
7 to 9, Your Lordship. But actually, my humble submission is that from 8, there is 2008, the wages came into being, Your Lordship.
So the actual difference will be not even.
No, Your Lordship, this is 2 lakhs, almost 2 lakhs per
My
person.
lord, notification that.
When is the date of the notification?
Notification
Your Lordship.
49/2006, my lord.
No.
Notification. SO number
Just a minute, let me finish,
151.
Mr. Das, let me finish, then you will just come in, Your Lordship. Your Lordship, that is. Here, this is referring to, because there is a particular discussion, Your Lordship. There is a particular, Your Lordship may come to page 35, Your Lordship. In the discussion, Your Lordship, by the authority.
38.
35, Your Lordship, internal page 16.
Yes.
There is a reference to SO number 1521 dated 14/9/2006.
Yes.
That is construction of maintenance of roads, runways in building operations, Your Lordship. Scheduled employment defined is no way different from the tender given to OP number 1. Upkeep and improvement of the premises. Hence, it can be concluded to be a scheduled employment as defined under section 2G. The work done as mentioned in the tender agreement is so and so and so. However, when the applicant has claimed himself to be a Mali, Your Lordship, the employee is a Mali, working in the establishment of OP number 1, the authority does not find any logic to dispute his engagement. Thus, the applicant was doing the unskilled nature of job.
No, where do you get 2008? There was no mention of 2008.
2008, Your Lordship. Your Lordship may come to page 23 that I was referring. I'm sorry. 23, Your Lordship.
Oh, no, I think page 17 bottom, sir.
17, Your Lordship.
page 17, internal page 17, page
Yes.
36.
Yes. Ma'am.
The OP number 2 has accepted that sweepers are covered.
Yes, 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 yes. Your Lordship. Yes. Yes, sir. That I was in. Under the schedule implement with implement 7/8/2000. Your Lordship is correct. I'm sorry. Your Lordship. By the government of India, and as such, they are ready to pay the minimum wages applicable to them as per the central government notification. This there is no dispute, Your Lordship. That I am only pointing out, Your Lordship. From 2008, 7/8/2008 till 2009, Your Lordship, when our tender.
Mr. Das, why don't you agree that they can pay from 7,000, 2008?
Yes.
My lord.
Only for 1 year's difference, sir.
Yes.
My lord.
That will put an end to all this unnecessary litigation.
Yes.
My lord, the notification speaks construction or maintenance of roads and runways or building operation. That is maintenance, upkeep and improvement of the premises, my lord. All are unskilled worker, my lord.
No, date when they were brought within the purview of the central government notification. That is the date. Crucial date is that.
Yes.
You say a very short point arises for adjudication in these bunch of petitions, all of which are by contractors supplying labor force for work in the
Regional Service Center, Your Lordship. Science Center, Regional Science Center at Bhubaneswar.
We can come to the page 16 in 49 2006. Page 16. At 35, page 35, internal page 16.
No, they were to be engaged in the
7 years.
Birla Institute of Technological, Birla Industrial and Technological.
That has taken the contract, Your Lordship, and they have engaged me as the contractor, Your Lordship.
That's right. But they were to be working there.
Contract was taken by BITM, Your Lordship, Birla Institute of Technology and Museum.
Yeah, for working with the Birla Industrial and Technological Museum, bracket BITM.
Yes.
Kolkata, which is under the control of the, which is functioning under the National Council of Science Museums.
Yes.
Bracket NSCM, NCSM.
Under Ministry of Culture, my lord, Government of India.
Which in turn is under the administrative control of the Ministry of Culture, Government of India. We'll stop. The contract was entered into between the petitioner on the one hand and the BITM on the other on 17 September 2007, which was valid for a period of 3 months from 1 September 2007 onwards. We'll stop. The contract period came to an end on 31st August 2009. Paragraph. In the premises of opposite party number
4 years.
4, that is the Regional Science Center at Bhubaneswar. Eight casual employees were engaged for different activities. All of them were unskilled employees performing manual work. It appears that these employees approached the authority under the Minimum Wages Act 1948, bracket MW Act, claiming that they had been engaged as Malis from 3rd March 1996 onwards till 1st October 2009 in the premises of the OP number 4 and were engaged in garden work but had been paid less than minimum wages. Summons was issued in the present in that petition to the present petitioners.
May I intervene short here? Your Lordship, that is minimum wages under the central government, Your Lordship.
Under the central government.
Yes.
Correct.
Yes.
Paragraph.
Yes.
After replies were filed pursuant to the said summons, by the petitioner. The impugned order dated 25th August 2011 was passed by the Deputy Chief Labour Commissioner bracket Central at Bhubaneswar, inter alia directing that the minimum wages in terms of the Government of India notification shall be paid to the said workers for the period from 1st September 2007 to 1st October 2009. And further that they were not entitled to get the differential wages prior to 1st September 2007. Paragraph. Two objections have been raised to the impugned order. One is that in terms of the proviso to section 20 bracket 1 bracket 2, sorry, 20 bracket 2 of the MW Act, every application for claiming payment of minimum wages had to be made within 6 months from the date on which the minimum wages became payable. Stop. It is submitted that the claims dated back to 1996 onwards, and therefore for time bar, and that in terms of the second proviso to section 20 bracket 2, sufficient cause was not shown for the delay in making such application.
My lord,
And the second-
pardon in the face of the order, my lord.
The second objection taken is that while the workman became covered by the Government of India notification only with effect from 7th August 2008, the differential wages were asked to be paid from the date of the first engagement, that is 1st September 2007 onwards. Paragraph. It must be noted at the outset that the admitted case is that the workers did get minimum wages as per the state government notification. This is also evident from the impugned order, where the payments received by the workers have been set out in a tabular form. Paragraph. Since the payment in any event has been asked to be made only from 1st September 2007 onwards, the court is not impressed with the plea regarding limitation. Paragraph. As regards the second plea, however, the court finds merit in the contention that with the central government notification becoming applicable only from
7/8/2008.
7/8/2008, the differential wages, that is the wages paid under the payable under the central government notification and those paid already under the state government notification, should have been asked to be paid only from that date, that is 7th August 2008. Stop. Accordingly, the impugned order is modified by directing that the workers will be entitled to receive the differential wages from 7th August 2008 till 1st October 2009. Stop. The petition is disposed of in the above.
My lord, payment may be
Lordship,
made
just a
in
correction,
short
Lordship.
period, my lord.
My lord,
Payment may be
appearance of the
made-
Union of India is noted, my lord. I am the opinion of one.
My
And all
lord,
the
payment
council,
may be made within a short period, my lord.
The payment now be made within a period of 4 weeks or within a period of 8 weeks.
8 weeks, Your Lordship.
Ah, 8
Lordship,
weeks.
one correction, Your Lordship, the impugned order is by the Regional Labour Commissioner, not Deputy Chief Labour Commissioner. Your Lordship.
All right, regional
Regional
labor.
Labour Commissioner Central.
Central. Okay.
Good.
Up to item 35.
Weekly list item 36.
None appears to sustain opposition. All right. All right.
Weekly list 36.
36. May I please, my lord? In this case, my lord, the petitioner in the trust being a public charitable trust, my lord, it was established on 4/10/2000. And accordingly, he organized various cultural programs in every year in the social home, my lord. Thereafter, the petitioner's trust constructed a building where a Gopavandhu Pathagara was built up under the MP led and MLA led. Thereafter, RDA was handed over that building to the petitioner on dated 12 February 2004 under Annexure 2, my lord. The above project has been completed with the allotted fund under MP led and MLA led scheme. Thereafter, my lord, accordingly, the petitioner is paying the holding tax and became the consumer of OSCO, my lord, and pay the electricity dues. And on 4/12/2004, the secretary of RDA, my lord, ADM, wrote a letter to the Gopavandhu Welfare Trust at page 23 that you furnished all the detailed documents. And the petitioner furnished the detailed documents at page 25 that the trust has been established in October 2000, and under this trust a Pathagara is being managed, and Patha and a Kalyan Mandap where the function and marriage and birthday is organizing. That all on a sudden the RDA issued a notice to the petitioner, you vacate this land without showing, without any opportunity of hearing or hearing. Say you are asked to show cause. Yes, my lord, I filed the show cause. I filed the show cause. When did you file? Annexure 6, my lord. Annexure 6 never received by RDA office. Annexure 6. Which page say Annexure 6? My rejoinder, my lord. At page 16. What's the proof of that, sir? My lord, proof of delivery of that reply, my lord, I have given that abandonments in at para 9, my lord, of my rejoinder. In my reply, I have said that I have never received it. That the claim of RDA is that opportunity of hearing was given to the petitioner for execution. No, I don't understand. Annexure 6, if you come down, there is the proof of receipt. You seem to have gone and delivered it to the additional district magistrate. Received, my lord, received seal. Seal is of additional district magistrate, sir. ADM is the secretary of the RDA. I see, my lord. It is there, sir. The seal is there. 6, I have, in my reply, I have said that I have never received 6, my lord. They made an amendment that they went to the ADM. Whose seal is this? Pardon, my lord? Whose seal is that? Page 72. Whose seal is that? Annexure 6. That's the ADM office, my lord. ADM is the secretary. He's you're the appearance of the rural development authority, right? Yes, ma'am. It is not always the ADM is the secretary. ADM has a separate entity, and the secretary development authority is a separate entity. No, at this point, who was at this point of time, both the officials managed by the ADM. But that has been gone to the ADM. No, so he has put his seal and signature, sir. He has put his seal and signature. But in my reply, I have stated this particular Annexure 6 is never available in the office of the Rural Development Authority. How do you know that? I have stated in my reply. He's probably gone to the office of the ADM and delivered it there. But my whole case is, what is this case, my lord? No, but if you not heard him, then is he not entitled to be heard? This reply, whatever is given, should it not be considered? May I place my case, my lord? Well, this is a case regarding the notice of the unauthorized construction.
No unauthorized.
Unauthorized construction, my lord. That this,
See, is that an admitted position?
pardon, my lord? Yes, admitted position that they have made unauthorized construction.
Where have they admitted?
Yes, my lord.
Show us where the
Yes,
admission
madam.
is.
Page 12, my lord. Of the rejoinder, para 12, page 12. Para 12, page 12. Internal para, page 12. It starts from para 11, but people also will start from bottom of the para 11, page 11, para 12 towards bottom. The petitioner has never involved in illegal commercial activities. The opposite parties failed to specify the allegation of in the counter affidavit. The petitioner, at the instance of the local public, was going to install the statue of the great Uttamani Gopal Das. The local MLA wanted to install his statue in place of Uttamani Gopal Das. When the dispute arose between the parties, then the ex-MLA. And now your lordship, my kindly turn to my counter affidavit to the rejoinder. Here the deviation, there is a report of the.
Where is the admission, sir? The question to you was, where has he admitted that he has made an illegal encroachment?
That paragraph, they said that we are going to encroachment, that is for.
There's not encroachment, sir. This is about installing some statue.
Yes, yes, ma'am. That is construction work.
Don't, please be precise. You said they had encroached.
No, I'm extremely sorry, my lord.
Then
They have made illegal development, my lord. Illegal
this is not a development, sir. This is about a fight about installing a statue. Where is this illegal development? And where is the admission? Where is the admission? Yes, we have made some illegal development. Where is the admission?
Here they have stated that the notice is the stop construction of the.
So you hear them again and pass a fresh order. All right. It's a very short point.
Yes, my lord.
A very short point is involved in the present petition by the Gopabandhu Welfare Trust, a socio-cultural organization functioning in Rourkela, which challenges an order dated 15th December 2011, passed by the Rourkela Development Authority (bracket RDA), requiring the petitioner to stop any construction activity within the premises of the single quote social home, unquote, which had been placed with the petitioner for caretaking and management, and to hand over possession of the said home to the RDA within 3 days. Paragraph. The question involved is whether the impugned order is violating the principles of natural justice inasmuch as the petitioner's reply dated 16th December 2011 to the show cause notice dated 15/12/2011 was not taken into consideration by the RDA before passing the impugned order. Paragraph. Counsel appearing for the RDA first sought to contend that the above reply was never received by the RDA. However, from the copy of the reply enclosed with the rejoinder, it is seen that it bears the signature with seal of the Additional District Magistrate Rourkela, who admittedly at the relevant point in time was also Secretary of the RDA. Paragraph. Counsel for the petitioner then sought to suggest that there was a single quotes admission, unquote, by the petitioner of having carried out illegal construction in the single quote social home. First off, he referred to para 12 of the rejoinder affidavit. Full stop. The perusal of the said paragraph reveals no such admission by the petitioner. Full stop. The government concerns the dispute with the local MLA about installing a statue of Utkalamani Gopabandhu Das in the premises. Paragraph. Be that as it may, it now transpires that the impugn order dated 15/12/2011 was indeed passed without taking into account the reply submitted by the petitioner to the show cause issued to it on 15/12/2011. Full stop. In fact, the impugn order appears to have been passed in great haste, where not even 1 day's time was given to the to reply to the to hand over possession. Full stop. Consequently, the impugn order dated 15/12/2011 is hereby set aside. Full stop. It is directed that the RDA will now pass a fresh order after taking into account the reply dated 16/12/2011 submitted by the petitioner and after giving the petitioner a hearing. For this purpose, the petitioner will appear through its authorized representative before the Secretary RDA on 16th May 2022. Full stop. After hearing the petitioner, a fresh order will be passed by the RDA not later than 20th June 2022, and a copy of the decision be furnished to the petitioner within 1 week of its being handed down. Full stop. If the decision is adverse to the petitioner, it will not be given effective for a period of 10 days to enable the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of in the above terms.
One line, my lord, if your lordship kindly referred to my reply to the region, there the deviation report is there, my lord. What is the construction has already been made.
Then say, counsel for the petitioner, just add here, counsel for the petitioner referred to the reply filed by the RDA to the rejoinder, enclosing copy of a single quotes deviation report, unquote. It will be open to the petitioner to file a response to the said report before the Secretary RDA on or before, which is the date you are supposed to appear, 16th May 2022. 16th May. Which will also be taken into account by the Secretary RDA before passing a fresh order in accordance with law. Correct.
List item 37.
Cancellation of lease. I am the purchaser from the original lease.
Same order. How many such matters do you have? It's all coming in trickles. Every day you get up and pass one similar order.
Yes, yes.
How many such matters do you have?
Another 10 matters are there.
I will provide all the numbers.
I shall provide the numbers.
Yesterday, item number 40.
Item number 40.
No, every day there's one by one. So might as well pass all the.
I shall provide all the numbers. Today I shall provide all the numbers.
You shall. Achha. All right. Yes. Same order.
Every.
Which is the date we fixed?
25th April.
All right. No, date fixed before the
25th April.
25th April.
Yes.
All right.
List item 38.
Item number 38 may not be heard by this bench because
List before bench of which Justice Raman is not a member.
Also, let's see
on Monday.
Item number 10 of the supplementary list.
18th.
Item number 10 matters, I am appealing for the.
Item number 10 of the supplementary list. Also, that group, your lordship, in the full bench, your lordship has relegated those matters. On that day also, I have requested that may not be listed.
Submit the report within 7 days. Now.
My Lord Justice Raman is also filed the counter.
Disabled from hearing. What if remains, I am suffering because there is no interim order for protection.
We'll take it on Monday, sir.
Monday.
Item 10 is supplementary also list on Monday. All right.
Gratefully.
Much okay.
Weekly list item 39.
39, I am pardon to appear from BC minor. I am for the petitioner. Petitioner here in the writ petition challenging annexure 5 and 6, the recovery order which has been passed without hearing him and in violation to their guideline manner. Under annexure 1 and 2, he has released some benefits which they want to recover, and accordingly filed the writ petition. No counter has been filed, and our representation is pending under annexure 7. May I request your lordship may direct the opposite party to consider our representation and giving a hearing.
All right. All right. You say the challenge in the present petition are to recovery orders dated 17 November 2011 and 29 November 2011 issued by the Orissa Hydropower Corporation Limited. Bracket opposite party number 2. So the main ground of challenge is that the recovery orders have been made without any prior notice to the petitioners. So it may be noted here that while issuing notice in the present petition on 15 November 2012, it was directed that no recovery should be made from the petitioner pursuant to the aforementioned interim orders. That interim order has continued since.
Some recovery already made, my lord.
Paragraph, however, the opposite party number 2 has not filed any reply to the present petition. So this is despite service of notice. And some lawyers entering appearance on its behalf, although today none appears on its behalf. Paragraph. It is seen that the petitioner has already made a representation to opposite party number 2 on 25th February 2012.
Under annexure 7.
Paragraph. It's accordingly directed that opposite party number 2 will examine the said representation dated 25th February 2012, and after hearing the petitioner will pass a reasoned order not later than 1st August 2022. For this purpose, the petitioner will appear before the opposite party number 2 through its managing director on 16th May 2022, along with the downloaded copy of this order. Till such time the representation is disposed of, the interim order passed by this court on 15 November 2012 will continue. The petition is disposed of in the above terms. What's he say? Whatever, sir, let him appear for what it's worth.
My lord.
We have asked him to appear before the managing director, sir.
My lord, that in the meantime, petitioner has already retired, my lord. Superannuated from service on 30th 4 2013.
What are you suggesting, sir?
My lord, your lordship correctly directed to dispose of Section 7 with giving opportunity of hearing, and
right.
Petitioner is at liberty to file some fresh documents if required.
All right, it will be open to the petitioner to furnish further documents in support of his plea before the managing director. All right.
Right.
Weekly list for orders, item number 40.
MC case, none appears. Dismissal non-prosecution. after lunch. We'll come back after.
Supplemental list, fresh admission item number 1.
May I please minutes.
148.
No, here what has happened is the petitioner was originally assessed by the DCCT Milord, Bharatpur Circle Milords. Then the matter was carried up to the tribunal Milords. And if your lordship would kindly turn to page 49, Milord, is a part of the tribunal's order. Paragraph 8, Milord. It begins at page 45, but I'll take a lordship to the operating portion at paragraph 8, Milords. The tribunal, what they did, Milord, is they remitted page 50. We restored the appeal of the SSC to the file of the AO and direct the AO to frame the assessment de novo, considering the submissions to the SSC along with necessary documents after providing sufficient opportunity of hearing to the SSC. The SSC is also directed to cooperate with the AO positively for early disposal of the case. We order accordingly. And this order was on 16/3/2020. And the lordship would appreciate that a copy of the order was also forwarded to the DCIT Barampur Circle, Barampur, who was my assessing authority, my lord. Nothing happens for 2 years, my lord. All of a sudden, on 21st of March 2022, I received a letter, my lord, a notice from ITO Raigada, my lords. And that notice is, my lord, at Annexure 8, my lords. Annexure 7, my lords. And this was dated 21st of March 2022. I received it on 22nd of March. He gives me time only to 25th to respond, my lords. So my humble submission, my lord, is twofold, my lord, that ITO Raigada lacks jurisdiction to assess, my lords. And if your lordship would kindly turn to Annexure 5 at page 44. Till date, my jurisdictional assessing officer, your lordship got it at page 44, my lord.
It's still Barampur.
It's Barampur, my lords. It's ITO Ward 1 Barampur, my lords. So my humble contention is twofold, my lord. One, my lord, ITO Raigada does not have the jurisdiction to assess me, my lords. Two, my lords, since the deputy commissioner was the assessing authority at the relevant point of time, and the tribunal having remitted matter back to the assessing authority, my lord, in all fitness of such things, my lord, it is the DCC who has to assess me, my lords.
Yes.
Third ground, my lord, is natural justice, my lords.
My lord, this was sent, my lord, as I gathered information, my lord, oral information, my lord, they have stated this was sent for the National Faceless Center, my lord, for adjudication as per the current procedure, my lord. But because the reassessment proceeding which has been initiated for the self-same year and assessment order has been passed and the appeal has been pending for the CIT appeal by the SSC, my lord, for that jurisdiction has been assigned to, my lord, the ITO Raigada, my lord.
But at least 127, your lordship is aware that before a transfer, the SSC has to have a reasonable opportunity of being heard, my lord.
Because, my lord, the National Faceless Center didn't accept it due to pendants of the appeal for the self-same year, my lord. For that, the Raigada ITO has been.
No, how did you get transferred to Raigada without notice to him?
And that took 2 years thereafter, my lord. Nothing happens from 2020, my lord, till 2022. That's 21st of March 2022. He gives me time till the 25th.
Now, during this period, my lord, the CBD as well as National Faceless Center were asked, my lord, to take up the matter as per the current procedure. And on
this was the first
17th of March, my lord, CBDT has made direction to the ITO, my lord, Raigada to take up the matter.
And in such a tearing hurry, he gives a notice on 21st March. Yes. And he's already passed the order on 29th March.
29th. And 25th was the last date for compliance. So it's all, my lord.
Anyway, you'll have to file a reply, I suppose.
Yes,
notice, Mr. Mahapatra accepts notice.
I had an alternate prayer, my lords. If your lordship, the prime officer satisfied, my lords.
I don't know if we need to know the reasons because it will then send you back to Raigada then.
No. It has to be Deputy Commissioner Income Tax, Barampur.
Barampur. So unless we know the reasons how and why they transferred it to Raigada, we can't deal with that. I don't think he can concede that it can go to Barampur.
Yes, let me take instruction.
Yeah, I know. Correct. No, and how did it go to Raigada?
And 127, your lordship knows, my lord, the SSC has to be heard, my lord.
Correct.
Then there may be a transfer for several reasons, but a chance of hearing to the SSC is necessary, my lord, before it is transferred.
Correct.
To another jurisdiction.
And violation of principles of natural justice is still
In the meanwhile, you've been filing returns, but returns are online now. so-
online,
Ah,
online.
sorry. All right.
And 26, to page 26, he admits that this is the first notice dated 21st of March, 2022.
Right. Mr. Mahapatra accepts notice for the opposite parties and states that he'll file a reply within 4 weeks, rejoined for the next date. In the next date of hearing, no coercive action shall be taken against the petitioner.
That annexure 1 and 2 be kept in abeyance.
Sorry?
Annexure 1 and 2 be kept in abeyance.
1 and 2, yeah, both annexures 1 and 2. No coercive action, I said.
And also this 271 penalty that has to be also kept in
No,
abeyance.
the better to say no coercive action. That takes care of everything.
Greatly obliged.
Right. List on 23rd August.
23rd August. Much obliged.
Supplementary list item number 2.
May I please address? The petition
Yes.
before my lords, as the principal CIT Bhubaneswar Range 1, my lord, has invoked section 263 of the IT Act as against a completed assessment passed on dated 22nd 12/2017, my lord, for the assessment of 15 and 16, my lord. So far as section 263(2) is concerned, the period of limitation based on which the principal CIT can assume his jurisdiction, that is within the period of 2 years. That is clearly mentioned under section 263(2), my lord. No order shall be made under subsection 1 after the expiry of 2 years from the end of the financial year in which the order sought to be revised.
How do you explain this limitation?
Yes, Lord, I'll explain. Your Lordship, kindly see page 21, the order. He has accepted the notice and is participating in the process. He has not whispered about the limitation.
No, but that's not.
Then I come, then later part I am coming. Lord, it is the assessment dated, Lordship, see running page 2 of the writ petition. 22/12/2017, the scrutiny assessment was completed.
Yes.
Then, Lord, it is aimed on 31st/3/2018. Then 2 years. Lord. Thereafter, Lord, by virtue of the notification, extended notification passed by the, you also remember that notification, relaxation, taxation and other relaxation amendment.
Now you're using that for
Yes,
everything.
yes. By virtue of that assessment, this order has been passed. And more interestingly, he has not whispered anything before the official. And the next part is, what is agreed? The review author not passed any order.
Against this, you can go to the ITAT.
Yes, and next part is, what is order passed? Order passed to deal.
So Mr. Patnaik, you withdraw and go to the ITAT.
Yes.
My lord, my humble submission before my lords, when the statute has not permitted to.
No, but the extension of time, this is the COVID.
My lords, similar matter before my lords is fixed on 11 July 2021.
No, that will deal with.
That is 148 notice, my lord.
That's okay. That is different. That is different.
Very same thing, my lord.
No.
Very same thing.
No, sir. Sorry. No.
This is very same thing that is.
No, sir. No. This is not the same.
They are only taking the help of that extension of time due to COVID. Now
That's
he's taking
okay.
that step.
We'll deal with it there, sir.
Sir,
Because this is the notice is 26/2, there it is after 1/4. That's why. In all those matters, it is after 1/4, sir.
And this is after.
And they are
No, this is 26/2, sir. The notice is 26/2.
No,
We'll anyway not entertain this, sir. The court is not inclined to entertain the present petition.
My lord, I
Since a
will
remedy of an appeal before the income tax appellate tribunal is available to the petitioner. Permitting the petitioner to avail of such remedy, the petition is disposed of.
my lord, the delay may be contained delays there.
All
Delay
right.
may be liberalized.
If the appeal is filed accompanied by an application for condition of delay, not later than 1st June 2022, citing the pendency of the present petition as the reason for the delay, it will be considered in its merits by the ITA in accordance with law. The court clarifies it is not expressed anywhere in the matter.
Supplementary list for orders, item number 3.
Item 3, my lordship, the virus of 2004 is under challenge, your lordship.
Similar matter is to 7th of July, madam.
Along with WPC number 2322 of 2020, your lordship.
All right, list along with
WPC number 2322 of 2020.
Yeah, on
7th of July.
7 July.
Oh, that's lordship.
Supplementary list item number 4.
I have removed one defect, but rest of the defect, your lordship may kindly ignore it because those are relating to margin, not line and other things.
So representation along with speed post receipt or at the petitioner's representation. Have you named the encroachers, madam?
Yes,
Yeah.
encroacher
Will be
party.
examined by the collector Kandamal.
Kandamal, yes.
Lordship
may kindly direct the Tahsildar.
Tahsildar Baliguda,
Baliguda, yes, that will be.
bracket opposite party number 3, and after issuing notice to the petitioners as well as opposite parties 5 and 6.
Yes.
And after giving them a hearing, the reasoned order shall be passed not later than.
Lord, instead of Tahsildar Baliguda, Tahsildar K. Nuaga, page 11.
Both Tahsildars.
Both Tahsildars.
They'll have to sit in the same place and hear them.
Yes.
Tahsildar Baliguda and K. Nuaga. All right. Not later than 16th August 2022. And the order should be provided to the parties not later than 23rd August 2022. The court clarifies it is not expressed to any view in the matter. Petition is disposed.
Oh, bless.
Supplementary list item number 5.
My lord, in this case, petitioners have filed the representation before the opposite part number 2. Removal of encroachment and renovation of recreation club established in the year
But
1967.
you not made the encroacher a party, madam.
Yes.
Encroach,
The encroachers are not made parties.
encroacher has not been, no, my lord. I have not made by law. I have filed the representation both before the collector and the.
No, but even there, you're not. All right. In the representation, you've named one bus stand Sahi Banig Sangha.
Yes, my lord.
All right. They are the encroacher.
Yes, my lord.
All right. The petitioner's representation dated 30th November 2020 shall be examined by the video.
Yes, my lord. Video.
K. Nuaga.
Yes, can.
And after hearing the petitioners and the opposite parties 3 and 4 as well as the what is it called? Bus stand Sahi Banik Sangha. The recent order should be passed not later than 1st August 2022 and the order shall be made available to the parties not later than 8th August 2022. The court clarifies it is not expressed in any matter.
Supplementary item number 6.
My lord. The fail matter for not hold the auction of a sand soiler.
Defects are not removed, I think, because despite 2 dates, direction was issued to remove the defects.
Correct.
He has not.
Still not removed. Last opportunity to remove defects within 1 week, list thereafter.
Supplementary item number 7.
Let me please, your lordships. My lords, on 30th 3, since there is a technical problem, lords, in connectivity of
All right. What is the main matter?
Lords, main matter is, lords, it is a public interest litigation, lords. The persons are the remote area of Puri locality and they are the, lords, the poor farmers, lords. They do have this land, lords, for grazing of their cows and all that, lords. But now the opposite part number 3, lords, the Tahsildar, lords, he is going to construct a park, lords. For that, we moved a representation before the collector, lords. Answer 3 minutes. That is, they are not considered. The opposite panel 2 has not on.
Right. For the reason stated, the application is allowed. Writ petition civil 6524 or 2022 is restored to file. In the main writ petition say, but okay, the petitioner's representation.
Annexure 3 minutes.
Bracket annexure 3 shall be examined by the collector Puri.
Yes, ma'am.
And after giving the petitioners a hearing, the reasoned order should be passed thereon not later than 1st August, and the order shall be made available to the parties not later than 8th August. If agreed to be open to the parties to seek appropriate remedies in the course.
Supplementary list item number 8.
Your lordship. Your lordship.
Defects,
will be granted. Your lordship. So next time I kindly.
All right, counsel for petitioner states that he will remove defects within 2 weeks, list thereafter.
Supplement is for admission item number 9.
In virtual mode, Millers. Am I audible, Millers?
Yes, Mr. Das.
Yes, Millers. Millers, this read relates to acquisition of 20 decimals of land for which notification was issued under section 4 and 6. It is the admitted case, Millers. If your lordship will kindly turn to page 18, paragraph 14, last 6 lines. But the LSC case number 19 of 79 was started for acquisition of 20 decimals of land of plot number 1434 by 1503, which has proceeded till the stage of declaration under section 6(1) of the LA Act by declaration.
The opposite party number 6 was to file an affidavit. What happened?
The company is required to file the response.
Lordship, give me 2 seconds there. What has happened? The land is a landlocked area. The land was taken over by the government. It was acquired by for EPICOL. EPICOL thereafter handed over the land to SN Corporation. SN Corporation was closed. It was again handed over to somebody. But we people are suffering on the ground that the land is with them. Then your lordship may kindly turn to their affidavit, Tahsildar's affidavit at page 34. Page 34 of the brief.
Mr. Das, last time we asked them to do something, we're just asking them, have they done it or not?
Yes, they have said. Because I have got the affidavit. They have one EP
May I please your lordship?
Stating that the land is within our possession, we are prepared to return them if they so like. And the land is within our boundary, but we are prepared to give them from a side of the boundary. Can it be after so many years in 79, the land has gone from my possession?
The lordship may see the affidavit filed by the company. That is most important because pursuant to the last.
No, filed by the state, your lordship may kindly see page 34. The state's letter. This is not a question of page 34 of the brief. It is Tahsildar Odapada's letter, my lord. Let this be placed, then whatever your lordship will decide. Which reference to letter on subject cited above. I am to intimate.
They're prepared to return it, sir. Mr. Monty, if they're prepared to return it, why don't you return the money and return the land?
No, money is to be returned to the company.
Yeah, that's right.
But so far as
land, Miller's land is a landlocked land. The land is within their campus. I cannot go there. They are offering to a site for last so many years. They are enjoying the land.
My lord, what has happened? His land is within the company area. It is
the company's deposited compensation with you.
But the land acquisition proceeding has been terminated. It has been withdrawn. So that is why we are not paid. If now they are saying that we are ready to return the possession, part with the possession in favor of the petitioner.
But he's been deprived of the land for so many years.
That is correct.
I am entitled under the new act, my lord.
Yeah, under 2013 he has to be paid.
Under the new 2013 act, my lord.
And you've been enjoying that money since for how many years, Mr. Monty? You enter into private purchase and be done with it. Give the market value of the land now.
Then that company is to go for private purchase.
They don't want the land. He doesn't want to take back the land. Then what is?
Then how what for government will take that land?
No, they've already deposited money with you. That's the affidavit. 1,59,533 was given to you in 1979, 40 years ago, 43 years ago. If you add interest to that for 43 years, it will be a very, very black sum.
That is subject to verification. But if
you verify that, but if that is true, then that money has to be paid to Mr. Das's client.
Yes, that is fair enough. Lordship is correct. If that money is available in government,
you add 6% interest on that money, and you pay to Mr. Das's client.
My lord, may pass an interim order to this effect. I will take it.
After so many years, what interim order? Only diverting the issue correctly, my lord. This case, lordship may see the dates, how many dates this case has been listed. State should be fair enough to come down with a proper proposal. This way, that way, my lords, this is not the way of state's behavior. Your lordship may see one decision. I have given the copy.
No, my lord, let me, the amount which the company has deposited, perhaps that is not for this particular, but it is for the entire,
I am not.
for so many plots. That amount your lordship.
No, the company's lawyer is here.
Yes, let him clarify
Yes,
what
ma'am.
is the amount.
No, this land is for 33.15 acres.
Yes. For that he has deposited. This is only 20 decimal. I think my Mr. Das client is only interested for 20 decimals.
We are not 20 decimals. It is a question, my lords. I am to get land compensation under the new act in view of the.
That is a different thing. My response submission is that the amount which has been deposited by the company, that is for 33 acres. You are concerned with 22, not that we have enjoyed the entire money for 40 years, that we have already disbursed it. Now the company is saying that the money which I have deposited, that is also inclusive of the land, the cost of the land which belongs to the petitioner. That I can take instruction to that effect. But if that is so, proportionately he will be compensated, proportionately, not that the entire amount can be reimbursed. Proportionately.
Because it is not the question of proportionately. Your lordship may see the Indore Development Authority judgment minutes 2002 8 SCC 129. I have been deprived of the land, my lords, by the state's action. I am entitled to get.
But so far as the compensation is concerned, he is entitled to the cost of the land over which he has got the title or not.
Today, he's got a point.
Whether 2013 Act or the old Act.
No, there's no old Act. It'll have to be 2013 Act.
Your lordship, if I again, because the last land acquisition is already withdrawn.
That's right.
If I pursue today, then it has to be under 2013 Act.
Correct.
That is there.
Correct.
But if I will go for direct purchase, what your lordship is suggesting, if I will go for direct purchase, it is a question of negotiation.
Correct.
Question of enforcement of 2013 Act will not arise.
So you decide what you want to do.
So only thing is what your lordship is saying, that we have retained the money of the company for 40 years. That is the, he has.
And you deprived him of land for 40 years. Both
yes, that is there. That is there. Not deprived. It is within the company premises. He is unable to go there.
No. Mr. Das's thing, Mr. Das's client has been deprived of that property.
And that part also needs verification whether this amount is
Mr.
inclusive of the-
Learned AGA states that he would like to respond to the affidavit filed by opposite party number 6, where it is stated in para 3.3 that way back on 20th January 1979, IPEBEL Refractories Limited bracket IRL had deposited 159,533.25 for acquisition of 33.15 acres of land.
Which is inclusive of the land of the petitioners.
Which includes the land belonging to the petitioners to the extent of
20 decimal.
More than 35 decimal. I think.
I'm sorry.
0.35 decimal.
I'm sorry.
0.35 decimal. It is further stated in the same affidavit in paras 4 that opposite party number 6 is ready to return back the above land covering the petitioner's 2 plots from the side of its boundary wall, adjoining the plot located just within the boundary wall, as one of the plots is located in the middle portion of its premises. And for doing that, it seeks the direction to the government to refund to it the excess amount together with interest. Paragraph Mr. S.D. Das, Learned Senior Counsel appearing for the petitioner, states that the petitioners are not interested in taking back the land since they have been deprived of it for over 40 years now, and they want to be compensated in terms of the 2013 Act. Paragraph. Mr. Manji states that he will file an affidavit on or before 20th June 2022, clarifying the stand of the government on both the above issues.
May I submit one thing? Well, company is the RO, requisitioning authority. Now, if the company says that I have no requirement of this land, and I want to refund.
Making wrong statement. Company is not the requisitioning authority.
EPICL is the reconnaissance authority, and EPICL is to allot the land to the company. The ultimate beneficiary is the company. Ultimate beneficiary is the company. So if now EPICL, what the EPICL will do?
Mr. Das, let him finish.
Your lordship may kindly, EPICL is the nodal agency. EPICL will take the land and then allot it to the company. Now the company is saying that we are not in need of this land. We want to return the land. We are in possession, but we don't want to. Then what? For what purpose we will acquire the land, and for whom?
You have enough land bank. It will also be added to that. That's it.
Because it is
See, you can't have it both ways. The man is losing his land. He doesn't get a penny as compensation, right? Not a single paisa. He's got his compensation. He's lost his 0.35 decimal.
Your lordship is correct in that way, but
we have to find an answer to his predicament. He can't use the land now.
Yes.
My 1 minute I will take, my lord. The land was originally given to one SN corporation. That was stopped. Then it was given to Ipitata. Now then it is given to Nilachal refractories or something like that. Because in the meantime, 3 hands have passed. The state is not disclosing that. State should be fair enough to do that.
We will file our response to this affidavit of the company.
List on 14 July.
Supplementary list item number 11.
Item 11, you will also kindly see the last order. Order dated 24/2/2022. I have filed one application, Miller, to bring the legal heirs on record.
That application is allowed. What's the matter about, sir?
Matter is regarding, my lord, whether in case of MCL, in an industrial dispute, whether the state level commission.
We have no instruction, madam.
That last occasion he submitted that since it's a money claim, legal heirs must be because the main opposite party has expired in the meantime.
So if there are no instruction, that's the end of the matter, sir. Counsel for the appearing for the LR states that he has no instructions. In that view of the matter, the court refrains from interfering.
And notice may kindly be issued, madam. Notice may kindly be issued.
All right. So it's a 2010 matter. What do you want? Do you think they're going to fight all this?
He was appearing for the original opposite party. Last occasion he submitted.
Under the impugned order, what are you supposed to do? Take the.
My case is that the labor dispute is maintainable before the central government, CGIT, not before the state. Correct. And it is a common, it's a mining operation.
Correct. Is limited. So it can't be the labor court. The challenge in the present petition is to an order dated. Yeah, not allowed. Now we are allowing. This is allowed. This is the challenge in the petition is to an order dated.
Annexure 4, Miller.
Yeah, 2nd August 2010 passed by the Labor Code Sambalpur, in this case number 13 of 2010. Asserting the jurisdiction of the Labor Court to entertain the application of the workman under opposite party number 1 workman under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 paragraph. Admittedly, the petitioner being a central government public sector undertaking is governed by the jurisdiction of the central government industrial tribunal.
Yes.
Rourkela.
No, Miller.
Bhubaneswar. Full stop. Clearly, the Labor Code Bhubaneswar would have no jurisdiction over the petitioner. Sambalpur would not have jurisdiction over the petitioner. On that short ground, the impugned order dated 2nd August 2010 is set aside. If the LRs of opposite party workmen wish to pursue any further remedy, to be open to them to file an application in accordance with law before the appropriate forum. The petition is disposed of.
Supplementary list item number 12.
which is allowed.
Item number 12.
12, dismissal non-prosecution.
Supplementary list item number 13.
May I please? Your my lord, the disciplinary proceeding in the year 1992 was initiated against the petitioner, my lord. Your lordship may kindly peruse the order passed in the disciplinary proceeding, that is at annex of 2, page 8, my lord. Punishment was imposed that no promotion for 10 years, no increment for 10 years, and she shall not be allowed to hold any responsible post for 10 years, my lord. Thereafter, I prefer an appeal, my lord. Your lordship may kindly peruse page 17, annex of 4, the order passed by the appeal committee, my lord. The order of punishment was modified. Page 18 is relevant, my lord. Penalty to that effect, that withholding of 3 annual increments without cumulative effect, my lord. The order of punishment was modified, my lord. But this was not implemented, and I was not granted with the promotion and the other benefits, my lord. Now I've been retired since 2013, my lord.
Yes, Mr. Mudli. Counter affidavit, what do you say?
They have not sought the copy of the.
Oh, copy of the counter affidavit be served on counsel to the petitioner within 2 days. Within 3 days, yes.
No, just now I am serving the.
All right, okay. The copy of the counter affidavit has now been served, today been served on counsel for the petitioner who needs time for instructions. List on 5th July.
Supplementary list item number 14.
Infractors. Sorry?
Item 14.
Infractors. All right.
Matter of the 2013.
All right.
Supplementary list item number 15.
None appears, this is not possible.
Supplementary list item number 16.
In this case, on 27 March 2017, State Council requested for time to file counter. The counter has not been filed.
What's the matter about, sir?
Matter relating to the appointment of judicial officers. under the-
Item 16.
16.
6628.
Assistant law officers. Assistant law
18.
officers.
That is 18. That is 18. Your, it is 16 is 6628 of 2016.
Correct. Sorry, madam.
None appears, this was not possible.
Supplementary list item number 17.
May I please, your lordship? My lord, I'm on behalf of Mr. R. Achari. My lord, the OP number 2 have filed an additional affidavit. Your lordship may kindly come to para 4, where it has stated that the work has started and by the end of 2022 it would be completed.
So that's fine.
The lordship may pass appropriate order.
All right. An affidavit has been filed. Where is that affidavit? NHA has filed an affidavit stating that, show the affidavit. This one. NHA has filed an additional affidavit. Stating that a new contractor or concessionaire has been, as well as technical consultants have been engaged, and they have resumed the work in a war footing, and that the work is slated to be completed to be the second half of 2022. Full stop. The details have been furnished as Annexure C to the affidavit. Photographs have been enclosed to show that construction of a substantial length of the stretch of the highway has been completed and kept motorable. Paragraph. Taking on record the above affidavit, the writ petition is disposed of, but with liberty to the petitioner to apply to the court for directions if the progress of the work is stalled for any reason whatsoever.
Oblige, Your Lordship.
Supplementary list item number 18.
May I please illustrate? In this case, the rule 9 of Orissa, the Superior Judicial Service rule has been challenged before your lordship, my lord. The notice has been issued since long, my lord. The counter affidavit has not been filed. The challenge was made by the law officers appointed by the government under law, assistant law officer rules are debarred from participating in the selection of the process for the appointment of the district judge, though they have acquired 3 years bar experience before appointment of as a law officer and discharging similar nature of duty like a public prosecutor, but they are prevented from participating in the selection, my lord, as the rule confined to the advocates only, my lord, for direct recruitment. Yes, Mr. Mudali.
In fact, you also can say this petition was filed in the year 2016. And at that point of time, the age of the petitioner was 42 years.
Oh.
In the meantime, more than 5 years. So it is now more than 47 clause, and more so, clause 2 of Article 233 puts a restriction is there. A person not already in the service of the union or of the state shall only be eligible to be appointed as a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. So there is a prohibition that unless that if you are an officer of the government, you will not be eligible to appear. But admittedly, he is an officer of the state.
That part has been examined by the Honorable Appeals Court in Deepak Agrawal case, and the this Article 233 of Section 2 has been considered, and the permission was given to the public prosecutors and government advocates who appointed by the government on payroll manner. That is the judgment, but they have allowed. And that only at the time of admission, the State Council obtained instruction whether the law officer are discharging similar nature of duty or dealing with the professional practice has to be explained. No. But the fact remains is you're 48 now. 48 years old now. So how can you be appointed? In view of that constitutional bar. The rule, I have challenged that rule. No, challenging is one thing, but you must be able to get some relief. Otherwise, it's no point. Give me the constitution. Which is the article?
Article 233. Clause 2.
No, where is the age part given in this? Age part rule 9
Age in the
itself.
rule itself, it is there.
Rule itself, page 14 minute. The petitioner was 42 years old when the present petition was filed. Today is well over 48 years old. In view of rule 9 sub rule C. Page 14.
Clause C of rule 9.
At page 9 bracket C of the Orissa Superior Judicial Service and Orissa Judicial Service Rules 2007. Page 14. 14 is it? 14.
Yes, 1
for 14. Cannot be above 45 years in order to be appointed as a direct district judge. That automatically petition been returned infructuous and it's disposed of as such.
Supplementary list item number 19.
Millards, item number 19, on the last occasion, Millards had adjourned it to 19th of...
No, see, there is a news item that has come to my notice. It was published in Orissa Post.
Please, Millards.
Do you have a copy of that?
I could not inform
Yes,
you.
Millards, regarding the Aadhaar issue.
That's right.
Yes, Millards.
So more than 2,000 beneficiaries have been deprived.
Please, my lords.
In
My
the
lords,
Rasulpur-
I would have brought it to my lord's notice on the next date, my lords.
No, it was too late, and so I said something has to be done right away.
May
So-
may I please, Your Lordship?
Huh.
My lord, what has happened is I've gone to the newspaper cutting, my lord. I had a discussion with the department people also.
Huh.
My lord, we still stand by the stand taken by the department in the affidavit that no beneficiary is deprived. My lord, what has happened? I think there are 2 letters from the department to the collectors. I think those letters have been misconstrued and misinterpreted. For the lordship's appreciation and.
No point in mind. Our construing those letters now. You have to set right this whole
We
thing.
are doing it, my lord. What I'm saying is, my lord, if your lordship will kindly peruse this, immediately we have called for the show cause from the person concerned.
No, but
supplier.
how are these persons going to get back their?
My lord, what is happening when a person comes to the center, my lord, he is asked for some identification. If he has a ration card, well and good. If he doesn't have a ration card, we facilitate his ration card.
Some
If he
team
doesn't,
has to be sent to Rasulpur, and you have to make sure that these people get their rations now.
that will do, my lord. That will do. But what is happening, my lords? The government is making a consistent effort for the UID for the
Which is a fresh circular you'll issue now for this, so that this doesn't repeat now. What has happened in Rasul?
Your lordship, if your lordship will only just peruse this letter, my lord, it is very specific. It says nobody should be deprived if no other seeding is done, my lord. My lord, there have been cases, my lord, in the last page, my lord, where even if very old person, leprosy patient who do not have fingerprints.
Ms. Patnaik, this is 10 July 2020.
My lord, there is, yes, my lord.
We are now talking of something that happened in April this year. So clearly these instructions are not being followed. Either you have to repeat these instructions.
We'll do that, my lord. We will
And
call
you
for
make
fresh-
sure a team goes to Rasulpur.
Yes, my lord, that will do.
And sets right the position now.
But that will do, my lord.
A news item titled single quotes Aadhaar seeding norm snatches poor's rice unquote has appeared in the Orissa Post April 6th, 2022 edition, which interior states that more than 2,000 beneficiaries in the Rasulpur block have been deprived of availing benefits under the National Food Security Act on account of failure of linking the Aadhaar cards with bank passbooks. Full stop. The report says how the public distribution system (PDS) dealers stated that they stopped supplying rice to the beneficiaries as per a government order, which made it compulsory to seed Aadhaar numbers of the beneficiaries with their bank passbooks. Paragraph. It will be recalled that before this court, a categorical statement was made in this petition by the state of Orissa that
No one is deprived.
no one would be deprived of rations due to non-linkage of Aadhaar This was noted by the court in its order dated 28 March 2022, which is just a few days before the news item appeared. Paragraph. Ms. Ashwata Patnaik has placed before the court copy of a letter dated 10 July 2020, written by the Commissioner cum Secretary to the government to all collectors regarding single quotes enrollment and seeding of Aadhaars in ration card database, unquote. And she insists that it has been made clear that even those not having Aadhaar will continue to receive the subsidized food grains by furnishing other proof like Aadhaar enrollment ID or a copy of a request made for Aadhaar enrollment or EPIC, etc., along with the ration card, unquote. Clearly, the above instructions have been misconstrued as a result of which more than 2,000 beneficiaries in one block have been deprived of their rations. A direction is issued to the Commissioner comes Secretary to the Government Food and Supplies and Consumer Welfare Department to forthwith issue fresh instructions to all collectors, reiterating the instruction about no beneficiary being deprived of rations because of non-linkage of Aadhaar with the bank passbook or seeding in the PDS database. Full stop. Further direction is issued that a team will be immediately sent to Rasulpur block to ensure that the 2,000 beneficiaries, 2,000 and odd beneficiaries who have been deprived of rations are immediately restored the benefits without any delay. Full stop. A compliance affidavit be filed before this court within 1 week. List on 21st, we have some. 21st, we have some. We can. 21st April.
Can you pay for 2 weeks, my lord? Because the team will go with them.
Or at 28th April.
Yes.
Or at list on 28th April. Or 29th at 10:30 then.
Okay.
Or 27th.
27th.
27th. All right, 27th April. All right.
Grateful.
Huh? What about 26th? 25th? 25th, all right, 25th April.
Okay.
We'll call it at 10:30 itself.
Yes, sir. Yes.
25th April at 10:30. All right.
Grateful.
Yes.
Ah,
But, and the date that is fixed to May.
that will remain, that will remain.
Oh, bless.
Supplementary list item number 20.
My lord, may kindly see the last order.
Subject to payment of 3,000. Nothing has happened.
Till that, no counter has been filed.
No, we have filed the counter and also paid the.
But you not served a copy on him,
No copy has
obviously.
been served.
The counter has come on record.
Yes, my lord.
Counter has come on record. The copy of the counter affidavit filed by opposite parties 2 and 3 be served on Mr. Bose the next 3 days. Rejoinder thereto, if any, be filed with the next date. 13 July, sir.
Yes, my lord. My noting shows that it has been served on 28th of February.
Anyway, you give me
Counter and IA both.
No copy has been served. They may have a noting, my lord. Everything is possible. Less it is said, my lord.
All right.
Supplementary list item number 21.
In this item 20, since the opposite parties are all judicial.
1 minute, Mr. Bose.
And since all the opposite parties are judicial officers and my lords have imposed a cost, and I have filed a petition to recall that order. And we have already deposited that amount. But on since all the opposite parties are judicial officers,
so
we have filed an IA for recall for deletion of that person only. Because that may be a stigma in future.
Stigma for whom?
For non-filing of counter cost has been declared.
Malad, I have
See,
not.
the rule applies across the board.
Cost has been paid.
Let the IA come, let's see.
No, IA is there, man.
No copy has
Flag
been.
C.
All right.
And that cost deposit receipt is at flag X.
Why recall? 3,000 has been paid.
It has been paid.
Why recall now? We don't want that High Court Bar Association to refund to you 3,000.
No refund. I also don't pray for refund. But so far as future is concerned, because all the opposite parties are judicial officers. So that's why.
What will they do? I mean, I don't understand. What is going to happen? You say it's clarified that the order imposing costs will not be construed adversely vis-a-vis the opposite parties in future. Got it.
But let them submit both the copies.
All right,
Counter and
all right.
I.
The application is disposed of. All right.
Supplementary item 21.
May I please, my lord, the substantial question of law at page 6, my lord. I'm pressing only one question, that is Roman IV, my lord. Whether the learned tribunal has correctly decided the appeal after considering the second proviso of section 40A IA of the IT Act, that the appellant cannot be treated as assessed in default under section 2011 of the IT Act if the recipients have included the receipt paid by the appellant in their respective returns of income and also paid taxes on the same, and there is no liability to deduct tax. And as per Annexure 3 series, they have already paid that, disclose the income and paid the tax as per their return income. And lots of the decision already covered. The mystery is now covered by the decision reported in 377 ITR 635 Delhi. My lord.
Who's for the other side?
Mr. Mahapatra.
He was there. The morning he was there.
Yes, my lord. Para 12 is the relevant, my lord.
Oh.
Para 12 is the relevant, my lord. Para
That's a
9,
landmark.
10 and 11, 12. 12 is more.
Pass over. All right. We'll pass it also.
Oh.
Supplementary item 22.
I please your lords. This is an appeal under section 260 Income Tax Act for the assessment year 1230. I have formulated the question of law.
Not entitled to deduction of 10% of aggregate average advance to its branches, basing on the population criteria.
Yes. This is the only question of law.
No, two questions. Some definition of rural branch.
Yes, has been defined in explanation to section 36 of the Act. Rural branch has been defined that where population on the last census exceeds 10,000, then it will cease to be rural branch, it will become an urban branch. So my respectable submissions, section clearly provides any average, aggregate average of 10%, 10% given to rural branches by the bank, including a cooperative bank.
No, what is the population in your branch? In your
My population branch exceeds 10,000.
exceed 10,000. Then you can't get the benefit of rural branch.
Let it be interpreted. Explanation should be interpreted. Whether the explanation will defeat the very purpose of the act or not. That in interpretation I have brought. What is the meaning of explanation by the Honorable?
Rural, urban, I mean, that's explanation is part of the section itself. It's not a proviso. No?
The explanation has been given to part, but explanation must not defeat the purpose of the act.
No, not defeat.
But because the very purpose of the act.
Brings out an intention of the legislature.
Let your lordship kindly see. This is also not on particular subject. It is in respect of settlement under the Service Tax Act. The lordship had occasion to explain or to interpret the word explanation. 8 hours.
You mean to say it cannot narrow down?
There. Let it be admitted and paragraph.
All right, we say admit the following questions of law are framed for consideration. Questions 1 and 2 in para 11.7. The paper books have already been served on learned counsel for the department. Extra copies be served within 2 weeks.
Let's stay. I have already deposited a major amount, 86. No, 86 lakhs I have deposited. Then
You already deposited?
Yes, I have already deposited 86 lakhs. Paragraph 3 of my stay petition.
All right, that stay application, you say it is stated that the
86
appellant
lakhs.
SSC has already deposited rupees 86 lakhs with the department. That view of the matter, no further coercive steps be taken against the appellant during the pendency of the appeal. The application is disposed of.
Published.
86, no, 86 is 1/3 almost.
Relief has been given.
It's all right, it's all right. They are a rural bank, is it?
Rural.
Ah.
चालू नहीं बोला.
List on 12 September.
12 September. 12 September. Yes, ma'am.
Supplementary list item 23.
Ah. All right.
So one case you lordship, so that.
All right, in view of this, we see in view of the decision of this court dated 5th April 2022 in IT 132 of 2018.
Yes.
Bracket Principal Commission Income Tax versus Messrs. Ahimsa Vinimay Private Limited. The court declines to frame the issues, declines to frame the questions as urged by the revenue in the present appeal, arising out of the order dated 19th April 2018 of the ITET Cuttack Bench Cuttack in IT SS number 42/CTK/2018 for the assessment year 2008-9. The appeal is accordingly dismissed.
Supplementary item 24. 24, your lordship fixed it on 30 June.
Or group case. Or the Neelachal Ispat. List on 30th June along with IT numbers 56, 57, 56 to 60 of 2007.
Similar issues, not all these questions are same, therefore.
Supplementary item 25.
25, lordship, see, this is order, deletion of penalty under section 271D of the Income Tax Act. But here the question is whether the tribunal is rightly held that the penalty for non-compliance of 269 SS, non-compliance, this no penalty has been imposed. Lord, the order has been passed. You lordship see the internal page 3 of running page 12 of the tribunal. But totally not, he has not been not improperly not in concerns with the section 269C SS is passed, and therefore this another two court of this in 2017, Honorable Rajasthan High Court has rendered a judgment in similar fact and circumstance case, and your lordship see as the revenue has filed the
Correct. Just a notice returnable. It is 30th June.
That's a two question lot.
No, notice. We just say notice. Returnable 30th June. Right.
After matter item number 21.
Mr. Mahapatra is still not here. 11th some other day.
Yes.
Mr. Mahapatra is not available. Mr. Mahapatra of the department is not available despite a Passover. In the interest of justice, list on 21st July.